I may pardon to make a mention, my lord. Item 62. It's a Monday one.
All right.
Quickly list item number 46.
May I please, Lordship?
What is your good name?
Pragya Paramita Mohanty, on behalf of JNV SHRI.
Madam, one problem is there that these are all 302 cases. So it's a jail criminal appeal and it requires 10 years of practice.
Yes, Lordship. I
You
have
have completed
yes,
10 years.
2008 my
Then
enrollment.
it's all right. Give it. Not a lucky now. But ask your senior to remain present because the case has been entrusted to him. It is not a private brief that he can assign you to argue the case. There is some problem in jail criminal appeal. Right? Your senior is present today in
Yes,
court.
sir. He is on his legs. He is
No,
on
it's all right. Ask him to come. You argue. You both the names will be reflected in the judgment. There is no problem. But this is some practical difficulty that jail legal aid has assigned the matter to a particular advocate, right? Looking at his experience, he cannot just give it to another. It's not a private brief that he can engage his so you are associate with. There is some problem. So, all right. All right, you argue, start your argument, ask your senior to come. It's a 302 and life imprisonment is there,
yes,
right?
Lordship.
All right.
This case is based on the under section 302 and life
Okay, you
convicted.
come to the first information report, right? That is at page 31.
Yes, sir. Lordship, the FIR has been lodged on the basis of the statement revealed from the PW2. That is extrajudicial confession, Lordship.
We'll go to that, but first let us know the case. Okay.
Yes, Lordship.
You come to the FIR.
May I place it, Lordship?
Yes, of course.
Mahasaya Mu Panuva Pradhan.
He is PW?
He is PW1, Lordship.
Okay. Yes.
ମହାଶୟ ମୁଁ ପାଣୁଆ ପ୍ରଧାନ ବୟସ 48 ପିତା ପରମେଶ୍ୱର ପ୍ରଧାନ ଗ୍ରାମ ରୂପଗାଁ କୁମ୍ଭାର ସାହି ପୋଷ୍ଟ ଚକପଦା ଥାନା ଟିକାବାଲି ଜିଲ୍ଲା କନ୍ଧମାଳ ଲେଖି ଜଣା କରିବା ରିପୋର୍ଟ ଏହିକି
That means this Parameshwar Pradhan is the deceased.
Yes, Lordship.
Okay.
And his father.
ଏହିକି
ଯେ ମୋ ବାପା ପରମେଶ୍ୱର ପ୍ରଧାନ ବୟସ 75 ବର୍ଷ ଗତ ଗୁରୁବାର ଦିନ ଅର୍ଥାତ୍ ତା ତାରିଖ 2/9/2004 ସକାଳୁ ପ୍ରାୟ 7 ଘଣ୍ଟିକା ସମୟରେ ଆମ ଘରୁ ବାହାରି ହାତରେ ଗୋଟିଏ କୁଡି ଧରି ଆମ ବିଲର ପାଣି ବୁଲାଇବା ପାଇଁ ଯାଇଥିଲେ। ଉକ୍ତ ଦିନ ରାତ୍ର ସୁଦ୍ଧା ମୋ ବାପା ଘରକୁ ନ ଫେରିବାରୁ ମୁଁ ଆମ ଗାଁର ଆଖପାଖ ଜାଗା ଏବଂ ବନ୍ଧୁବାନ୍ଧବ ଘରମାନଙ୍କରେ ଖୋଜିବାରେ ତାଙ୍କର କୌଣସି ଖବର ପାଇଲି ନାହିଁ। ତେଣୁ ମୁଁ ଗତ ତାରିଖ 24/9/2004 ଏହି ବିଷୟରେ ଟିକାବାଲି ଥାନାରେ ଜଣା କରିଥିଲି। ଆଜି ଅର୍ଥାତ୍ ତାରିଖ 27/9/2004 ସକାଳେ ମୁଁ ଆମ ଗାଁ ପାଖ କରୁଣା ତୈଳ ଗ୍ରାମର ସୁଦାମ ଭୋଇ ପିତା ସୁରେଶ ଭୋଇ ଠାରୁ ଶୁଣିବାକୁ ପାଇଲି ଯେ ଆମ ଗାଁର ମୋର ବଡ ବାପାଙ୍କ ପୁଅ ଭାଇ ପବିତ୍ର ପ୍ରଧାନ ପିତା ଜଗବନ୍ଧୁ
ସୁଦାମ ଭୋଇ is PW2.
Yes,
Yes. ଶୁଣିବାକୁ ପାଇଲି ଯେ ଆମ ଗାଁର ପଢନ୍ତୁ।
ପବିତ୍ର ପ୍ରଧାନ ପିତା
ପବିତ୍ର ପ୍ରଧାନ is the appellant. Yes.
ଜଗବନ୍ଧୁ ପ୍ରଧାନ ମୋ ବାପାଙ୍କୁ ପ୍ରାଣରେ ମାରିଦେଇ କେଉଁ ଆଡେ ଲୁଚାଇ ଦେଇଛି। ତେଣୁ ଏହା ଶୁଣିବା ମାତ୍ରେ ମୁଁ ଆପଣଙ୍କ ପାଖକୁ ଆସି ଲିଖିତ ଆକାରରେ ଏହା ଜଣା କରୁଅଛି ଯେ ଏହାର ତଦନ୍ତ କରି ମତେ ନ୍ୟାୟ ଦେଲେ ମୁଁ ଚିରୋପକୃତ ହେବି।
Okay. So come to the framing of charge, page 35.
Yes, Lord.
Read the charge.
Hereby charge you, Pavitra Pradhan, as follows. Firstly, that you on 2nd day of September 2004 at 9 a.m. at Rupagaon village in your house committed murder intentionally or knowingly, causing the death of Parameswar Pradhan and thereby committed an offence punishable under section 302 IPC and within my cognizance. Secondly, that on the aforesaid date at night at village Rupagaon, in furtherance of your common intention with accused Gokula Pradhan, a juvenile, knowing or having reason to believe that the offence of murder punishable with death has been committed, caused certain evidence of the commission of said offence up to disappearance, namely concealed the dead body by burying the dead body in your land with the intention of screening yourself from legal punishment and thereby committed the offence under section 201/34 IPC and within my cognizance.
So it is a case based on circumstantial evidence,
Yes, Lord.
right? So what are the circumstances according to the prosecution? Is it been sum of where in the judgment?
Yes, Your
Yes,
Lordship.
yes.
Which page?
Page 14 and 15, Your Lordship.
14 and 15.
Paragraph
Okay,
9.
paragraph 9.
Yes, Lord.
Read that. Then we will go step by step.
The case in hand is to be gauged on the background of aforesaid principles. The circumstances highlighted to fasten the guilt of the accused are as follows. 1. Motive. According to the prosecution, the elder brother of the accused suffered from prolonged illness and the accused was under the impression that the deceased had applied black magic against his elder brother and thus wanted to eliminate the deceased in order to cure the elder brother. 2.
Hmm.
That the accused made extrajudicial confession before the witness.
Who are those witnesses?
That is Lordship PW2.
Only?
No.
Okay,
Yes.
all right.
Third, the discovery of the dead body of the deceased from the land of the accused at the instance of the accused.
So this has been stated by, apart from IO. IO is PW?
IO is PW9.
Nine.
Lordship.
PW9 IO. Any other witness supported this aspect?
Yes.
No, Lord.
Yes, PW5.
Supported?
Yes.
Okay, all right. We'll see that. Okay, come to the next page.
Third one is the discovery of the dead body of the deceased from the land of the accused at the instance of the accused while in police custody.
Okay.
4. Leading to discovery of the weapon of offense given by the accused.
Again,
while in
this is
custody.
apart from PW9, the IO. Any other witness has supported?
PW5, Your Lordship.
Same
Yes,
witness.
same.
Okay.
Lordship,
PW5.
PW9 is also not supported.
No,
Lordship.
no. PW9 is IO.
Yes,
PW9
Lord.
is there. We'll see that. We just want. Yes, next.
5. Leading to discovery of the spade of the deceased given by the accused while in custody.
Spade of the deceased. Okay. All right. This is also PW9 IO and that
5.
5.
PW5.
Okay. So that means Ajit appears. Who has stated about this motive part? That
PW2.
PW?
2, Your
2.
Lordship.
Okay. So practically, so apart from the IO, the two independent witnesses who are material on different aspect are PW2 and PW5, right?
Yes.
So let us come to the evidence of PW2. Okay,
That is Lordship page number 45.
45. Okay.
Sudam Bhoi.
Yes. May I please?
Yes.
Deposition of witness 2 for the prosecution aged about 25 taken
No, no.
on.
Read that.
Correct.
Come to the paragraph 1.
I know the deceased. Deceased is related to me as grandfather and accused. The informant are my uncle.
Deceased is?
Deceased is related to me as grandfather.
हाँ
तार जेजेबापा
हाँ
and accused.
and accused माने कौन?
ଲେଖାର ଇଏଟା ଭୁଲ ହେଇଛି knows the accused also.
Yes, accused को भी जानी चाहिए, accused
No,
are
deceased is also related to the accused or what?
हाँ, yes Lordship.
Oh, अच्छा अच्छा. So it
But
would
it is long distance relation.
no, it's all right.
Yes,
It's
that
a-
is how he is.
हाँ. So grandfather deceased related to Miss Wanso and it was like I am also related to the deceased type of area. That's chadam. The informant happen.
The informant are my uncle, but not my mother's brothers.
Informant माने कितने जन थे?
Only one informant.
So-
His
पूछेंगे भगवान. पाणुआ प्रधान सिंगल तो आर कौन लगाला? All right, ठीक है. हाँ पढ़ो.
2. About 3 years back, the deceased was reportedly missing. 5 to 6 days after his missing, I had gone to accused village to buy a hen. I had gone to the accused house to see accused elder brother who was ailing. While I was inquiring of the ailing person's health condition, the accused told, ସନାତନ ଏଥର ଭଲ ହୋଇଯିବ, ଯିଏ ଗୁଣି କରିଥିଲା ତାକୁ ପକ୍କା ହୋଇଛି. When I inquired
ताको
as
पक्का है जी.
पक्का ହୋଇଛି, yes Lordship.
पक्का माने कौन?
ତାଙ୍କର local language.
अच्छा.
We'll see.
That has been interpreted by the
By the-
trial judge, Your Lordship.
All right.
माने he has been finished or what?
Yes,
Yes.
हाँ. Okay.
meant killing. That
Ah,
that is the
All right.
interpretation.
ताको पक्का है. अच्छा.
When I inquired as to who was the Gunia, he told that the deceased had applied witchcraft to Sanatana, his elder brother. The accused requested me not to disclose the facts to others. I understood from his statement that the accused I had killed the deceased and buried the dead body.
Buried the dead.
Next day, I told PW1 what I had heard from the accused.
PW1 is that informant, right?
Informant, Lordship. During the cross-examination, I am not able to give the dates and time. Deceased's house is in Kumbharsai, a hamlet of Rupgaon. Accused house is in Rupgaon. The hamlet is about 1 kilometer away from the village Rupgaon. 4. No outsider was present when the accused was talking with me. From his house, I came back to my village, which is also 1 kilometer from Rupgaon, but in a different direction. In my village, I did not disclose to others what I had heard from the accused. Next day, I disclosed it to PW1 only. My relationship with accused and the informant is of equal distance. 5. I was staying at Fulbani when the deceased was found missing. Sanatana died last year. Sanatana is that elder brother of the accused. 6. I was interrogated by the police. It is not a fact that I have not stated before the police that 5 to 6 days after the missing of the deceased, I had gone to accused house to inquire about the health of his elder brother, and that time the accused told me, Sanathara ethara bhalo hoijibo, jiye guni karitila taku pakka hoichi. That when I inquired as to who was the Gunia, accused told that deceased had applied witchcraft to Sanatana. That I understood from that.
एवढा कोण किसी कॉइन
No,
पुलिस
entire
वगैरे
No,
don't
Lordship.
please come to the IOS evidence
That is
एवढा
Lordship.
तमने first time कहला court रे
Lordship, that
please
is
come
page
to that
number 59.
page number
59, Lordship.
no 59 is the IOS evidence starts about this confrontation which you have
Yes, it is
made
there, Your Lordship.
huh?
Pardon?
Cross.
About the evidence of PW2
Yes.
where it has been brought out that he has not acha I have examined Sudam Bhoi acha this
That
is
is page
paragraph
number
number 6
yes.
please read it out.
They are just
Oh,
thinking about
nothing is there.
Page 61.
Lordship, I had examined Sudam Bhoi. He had not stated before me that about 5 to 6 days after the missing of the deceased, he had gone to the house of the accused to inquire about the health of his elder brother, and at that time the accused told him that ଏଥର ସନାତନ ଭଲ ହୋଇଯିବ, ଯିଏ ଗୁଣି କରିଥିଲା ତାକୁ ପକ୍କା ହୋଇଛି, and that when he inquired from the accused as to who had applied the black magic, the accused told him that the deceased had applied witchcraft to Sanatana.
So Mr. Misra,
Lordship.
that means this statement has been made for the first time in court.
So there is an observation, Your Lordship may take page 21. The trial court has given an observation
Uh,
that the witness had in fact stated before the police, but the exact verbatim is not there. That is the
Oh.
observation of the trial court.
କୋଉଠି କହିଲେ?
We'll say
Not, sir.
161 is to be
ଆଚ୍ଛା
seen.
161 ଟା ଦେଲେ
Let's go.
ଦେଖି ମାନେ ଆମେ ଯଦି ଜିସ୍ ଟା ଆଣିବା ତା ଦେହରୁ ଯେ
ହେଲେ ବି ହବ।
5-6 ଦିନ ଆଗରୁ ମିସ୍ ମୁଁ ଯାଇଥିଲି ତା ଘରକୁ ମୁଁ ପଚାରିଲି ସେ ତାର ବଡ ଭାଇ ଦେହ କେମିତି
ଅଛି,
ଅଛି
ଅଛି।
ସେ ବିଷୟରେ
Lordship.
ସିଏ କହିଲା ଯେ ଏଥର ସନାତନ ଭଲ ହେଇଯିବ।
Lordship, before that, Lordship,
Verbatim ନାହିଁ।
କେତେ
Lordship, pardon,
ଏଟା
Lordship.
ଅଛି sir
Yes,
page
Lordship,
ଏଇଟା ବାହାର କଲ ଷ୍ଟେଟମେଣ୍ଟ
statement ଟା।
that is narrated in page number 16, Lordship.
wait let us go let us see that ନାଇଁ ସେଟା ନୁହଁ 161 statement
161 statement ଯୋଉଟା ଅଛି।
case
Judgment ତଳେ statement।
ହଁ କଣ ତା ନାଁଟା କଣ?
ସୁଦାମ
Sudam Bhoi.
ସୁଦାମ ଭୋଇ।
wait ସୁଦାମ ଭୋଇ ଦିଅ ଠିକ ଏଇଟା ନାମ ଏଇଟା ସୁଦାମ ନା ସୁଷମା?
Sudam.
ସୁଦାମ।
ଆଚ୍ଛା ସୁଦାମ ଭୋଇ ଆଚ୍ଛା ଅଲରାଇଟ୍ ମିଳିଲାଣି। ମୁଁ ଗତ ଶୁକ୍ରବାର ଦିନ ଅର୍ଥାତ୍ 17/9 ଦିନ ବେଳା ରୂପଗାଁ ମୋ ମାମୁଁ ଘର ଧାନ ଘରକୁ କୁକୁଡ଼ା କିଣିବା ପାଇଁ ଯାଇଥିଲି। ତାପରେ ମୁଁ ରୂପଗାଁ ତଳ ସାହିର ମୋର ସମ୍ପର୍କୀୟ ମାମୁଁ ପବିତ୍ର ପ୍ରଧାନଙ୍କ ଘରକୁ ଗଲି। ପବିତ୍ର ପ୍ରଧାନ ଇଜ ଦି ଆପେଲାଣ୍ଟ।
Yes.
ସେଠାରେ ମୋର ମାମୁଁ ପବିତ୍ରକୁ ଘର ପିଣ୍ଡାରେ ବସି ଥିବା ଦେଖି ମୁଁ ମୋର ମାମୁଁକୁ ପଚାରିଲି କଣ ମାମୁଁ ଭଲ ଅଛି କି କାହିଁ ମୁହଁ ଶୁଖାଇ ବସିଛି? ଏହା କହିବାରେ ମୋର ମାମୁଁ ପବିତ୍ର କହିଲା ଭଣଜା ଗୋଟେ ଭୁଲ କାମ କରିଦେଇଛି ତୁ ଏକଥା କାହାକୁ କହିବୁନି। ତୁ କଣ ହୋଇଛି ମୁଁ କଣ ହୋଇଛି ବୋଲି ପଚାରିବାରୁ ଯେ ତୁମ ଗାଁର କୁମ୍ଭାର ସାହିର ତୁମ ଦାଦି ପରମେଶ୍ୱର ପ୍ରଧାନକୁ ଗୁଣିଆ ସନ୍ଦେହ କରି ସେ ପ୍ରାଣରେ ମାରି ଦେଇଛନ୍ତି ଏବଂ ତାଙ୍କ ମୃତଦେହ ଏମିତି ଜାଗାରେ ଲୁଚେଇ ଦେଇଛନ୍ତି ଯେ କେହି ଜାଣିପାରିବେ ନାହିଁ। ଏହି କଥା ମାମୁଁ ପବିତ୍ର ପ୍ରଧାନ କାହାକୁ ନ କହିବା ପାଇଁ ଅନୁରୋଧ କଲେ। ଏହା ଶୁଣି ମୁଁ ଏ କଥାରେ ପେଟରେ ନ ରଖି ରୂପାଙ୍ଗର ମୁତାଫା ପାଣୁଆ ପ୍ରଧାନ ଓ ଆଚ୍ଛା ସୁଧୀର ପ୍ରଧାନ ତାପରେ ଆମ ଗାଁକୁ ଚାଲି ଆସିଲି। ଆଚ୍ଛା ବଟ୍ ଏଇ ଯୋଉ ପାର୍ଟଟା let us see that ଏଇ ପାର୍ଟଟା ତ ସିଏ କୋର୍ଟରେ କହିନି ନା। ଏଇ ଯୋଉ ପାର୍ଟଟା ସିଏ କହିଲା ଯୋଉ ଦାଦି ପରମେଶ୍ୱର ପ୍ରଧାନକୁ ଗୁଣିଆ ସନ୍ଦେହ କରି ସେ ପ୍ରାଣରେ ମାରିଦିଏ ମାନେ ଷ୍ଟ୍ରେଟ ଆୱେ କନଫେସନ ଯୋଉଟା ଏକ୍ସଟ୍ରା ଏଠି ଏ ଲାଙ୍ଗୁଏଜ ନାହିଁ। ଏ ଲାଙ୍ଗୁଏଜ ହଉଛି ସନାତନ ଏଥର ଭଲ ହେଇଯିବ ଯିଏ ଗୁଣି କରିଥିଲା ତାକୁ ପକ୍କା ହେଇଛି। this is an indirect thing but what has been stated here almost directly that ମୁଁ ତାକୁ ମାରି ଦେଇଛି। there is difference between the two. He has not named that to have killed the deceased. It's a direct confession is there in the 161 statement which is not there. If it is not there then how can reading this 161 the court will use it as substantive piece of evidence?
Lords, here
No,
Only
Yes,
case.
yes,
Lord.
Lord. Court has not taken that statement.
Not
Does yes.
Oh, achha, that not take. Then
Yes.
it's all right.
Yes, Lord.
Okay. So it is ମାନେ indirectly ସେ hint ଦଉଛି ଆଉ ଥରେ ଯଦି ପଢିବା ଆମେ page 45 ରେ ସନାତନ ଏଥର ଭଲ ହୋଇଯିବ ଯିଏ ଗୁଣି କରିଥିଲା ତାକୁ ପକ୍କା ହେଇଯାଇଛି। When I inquired as to who is that gunia, he told that deceased had applied Sanatan, his elder brother. The accused requested me not to disclose the fact to others. I understood from the statement that the accused had killed the deceased and buried the dead body. So this is the how the language is. So acha ଆଉ ଗୋଟେ ଏଇ ଘଟଣାଟା ସିଏ ଜାଣିଲା କେବେ ମାନେ ଯୋଉ ଦିନ ମିସିଂ ହେଲା ତାର 5-6 ଦିନ ପରେ ଜାଣିଲା, ରାଇଟ୍? ସେ କହୁଛି ନା 5 to 6 days after। ଏଇ ଯୋଉ ଏତଲାଟା ଆପଣ ଲଜ୍ ହେଇଛି ଏଇଟା କେବେ ଲଜ୍ ହେଇଛି ଆପଣଙ୍କର?
FIR has been lodged on 27
ହଁ ଏଟା much after ମାନେ 25 days after the occurrence ବା ଯୋଉ ମିସିଂ କହୁଛନ୍ତି ତାର 25 days ପରେ ଏଇଟା ହେଇଛି। ଏବଂ FIR ରୁ ମଧ୍ୟ ଜଣା ପଡୁଛି ଯେ ଏଇ ଯୋଉ ଇନଫର୍ମେସନ ଯାହା ତାକୁ ମିଳିଲା ସେଟା PW2 ରୁ ହିଁ ମିଳିଲା। Now you come to the language of PW, that FIR language ମାନେ ସିଏ ତାକୁ PW2 କଣ କହିଥିଲା? PW ସେ କହୁଛି FIR ରେ ଯେ ଆମ ଗ୍ରାମର ସୁଦାମ ଭୋଇଙ୍କ ଠାରୁ ଶୁଣିବାକୁ ପାଇଲି ଯେ ଆମ ଗ୍ରାମର ମୋର ବଡ ବାପାଙ୍କ ପୁଅ ଭାଇ ପବିତ୍ର ପ୍ରଧାନ ମୋର ବାପାଙ୍କୁ ପ୍ରାଣରେ ମାରିଦେଇ କେଉଁ ଆଡେ ଲୁଚାଇ ଦେଇଛି। ଏ ଡିଗିଂ ପାର୍ଟ କଥା ନାହିଁ, ଯୋଉଟାକ ସିଏ କହୁଛି ଯେ ମୁଁ ତା ଏଥିରୁ ଜାଣିପାରିଲି ଯେ ସିଏ ତାକୁ କୋଉଠି ପୋତି ଦେଇଛି, ସେ ମାରିଦେଇ ଏ ଜିନିଷ ନାହିଁ। ବଟ୍ ମାରିଦବା କଥାଟା ଅଛି, ବଟ୍ ଦିସ୍ ପାର୍ଟ ଇଜ ଦେୟାର, ଲୁଚେଇ ଦବାଟା ଅଛି। ଆଉ
ମାନେ ଡିଟେଲ ନା,
ହଁ ଡିଟେଲ ନାହିଁ। ଆଚ୍ଛା ଆଉ ଗୋଟେ ହଉଛି ଶୁଣିବା ପାଇଁ ଆମ ଗାଁ ଶୁଣ ଦେଖିବା ଯେ ଯିଏ ଗୁଣି କରୁଥିଲା ଭାଇ ଏସବୁ ମଧ୍ୟ ଏଗୁଡାକ ନାହିଁ ଆ ଦେହରେ, ଯାହାଟା FIR ରେ ଖାଲି ଶୁଣିବାକୁ ପାରିଲି ଯେ ମୋ ବାପାକୁ ମାରିଦେଇ କଣ କାରଣ ଫାରଣ ମଧ୍ୟ ଏଠି କିଛି ନାହିଁ FIR ରେ, ରାଇଟ୍? So that just we now you of course in detail he has not stated in the exact manner, but some kind of statement is there in the 161. अच्छा PW2 has been relied upon.
Yes.
Yes,
Right.
sir. But
No, just a minute.
Para 12 of the judgment. He has dissected.
No, PW2, if he is a witness to the motive and extrajudicial confession, that for that reason you have relied upon that evidence. So motive part the PW2 initial stage रे ଯେତେବେଳେ ସିଏ disclose କରିଛି ଘଟଣା PW1 କୁ, most likely that part has not been disclosed। ये जो गुणिया कथाटा ମୁଁ କହୁଛି, ଗୁଣିଆ କଥାଟା ହଉଛି ତ ଆପଣଙ୍କର motive ନା behind the crime।
Yes.
So
or else that would have reflected in the FIR.
Right. So that is what.
But in the 161 statement, it is there, which is tallied with the
161 of Taharo.
Of the of PW2, Your Lordship.
No, PW2 ଏ ବିଷୟରେ କହିଛି ଯେ ଯିଏ ଗୁଣି କରୁଥିଲା ଶୁଣନ୍ତି ଏଇ ଜିନିଷଟା ସିଏ ପ୍ରଥମେ ଯେତେବେଳେ 3-4 ଦିନ ପରେ ଘଟଣାର 3-4 ଦିନ ପରେ ଶୁଣିଲା ନା ସିଏ ଏଇଟା ତାକୁ କହିଲା, ତ ସିଏ ଆସିକିନି କାହାକୁ କହିଲା? ଇମିଡିଏଟଲି କହିଲା ତା ଭାଇକୁ, ଅର୍ଥାତ PW1 ତାର ବହୁତ ଦିନ ପରେ ପ୍ରାୟ 2 weeks ଖଣ୍ଡେ ପରେ ସିଏ ଏତଲା ଦେଇଛି ଯୋଉଥିରେ ଅନ୍ୟ ସବୁ କଥା ଅଛି, but this motive part is missing. That is what I am pointing out to you, that motive part is जो गुणिया जिनसटा FIR रे नहीं जे अछि, अन्य सब अछि जे ଆମ ଗ୍ରାମର ସୁଆଂଶୁ ଶୁଣେ କଣ ପାଇଁ ମାରଲା, that was the motive, ସେଇ ଜିନିଷଟା ନାହିଁ। Acha, now you come to because he disclosed about the occurrence before the occurrence mean ei jo part ta before PW1. Let us say what PW1 has stated,
Got
that what he has disclosed, that what PW2 has disclosed before him. Come to the evidence of PW1.
Page
Yes,
42.
36.
42.
May I place it?
Hmm.
Deceased is my father.
Hmm.
My father and accused father are cousins. Gokul, juvenile in conflict with law, who is a co-accused, is present. Accused elder brother's son. 2. 3 years and month back, my father left home at 7 a.m. to take water to our paddy fields.
Hmm.
Till evening, he did not return.
Hmm.
We went in search of him, but could get no trace. We searched for 21 days. Thereafter, Sudam Bhoi told me that
Sudan Bhoi means PW2, right?
Yes, sir.
Yes.
told me that we should not further search for my father as the accused had killed him and buried the dead body which Saddam claimed the accused confessed before him.
Hmm.
Thereafter, I went to the police to lodge report.
Hmm.
Exhibit 1 is the FIR and Exhibit 1 by 1 is my signature.
Hmm.
Pavitra's parents expired prior to the incident.
Hmm.
Gokul's father was suffering from poor eyesight for a period of 1 month.
Hmm.
Then, 2 days after the affair, the police interrogated the accused, and at that time, the accused confessed to have killed the deceased and buried the dead body in his fatherland.
Hmm.
At that time, I was present. Others were also present there.
Hmm.
Then the accused led the police to the spot of burial and pointed out the spot.
Hmm.
3 to 4 days thereafter, the police, in presence of the doctor and magistrate, disinterred the dead body of my father.
Hmm.
Then testes and pennies of the dead body were missing. There was cut off a small portion of his ears, a portion of his tongue, and tip of his right little finger. The doctor conducted postmortem at the spot. The police held inquest in my presence. Exhibit 2 is the inquest report and Exhibit 2 by 1 is my signature. Then the cross-examination.
Yes.
One deed writer to Tikavali wrote the affair. It was scribed as per instruction of the OIC. I did not report about the missing of my father. Sudam is my nephew through distantly. On the day following Sudam's information on accused confession, the matter was reported to the police. 9. The upper layer of the skin all
So
over
this is somewhat doubtful. On the day following Sudam's information on accused confession, the matter was reported to the police may not be correct because PW2 says 5 to 6 days after he came to know about this from PW from the appellant. But the FIR was lost as we find that it was lost. Missing was on 2/9/2004 and the FIR was lost on 27/9/2004. All right, you continue.
the upper layer of the skin all over the body and the tuft of hair were missing, but flesh was attached to the skeleton. But from his face he could be identified. I also identified my father from his wearing apparel. Before lodging of the affair, I did not report it to village gentries. Then I am not aware if the deceased had any enmity or ill feeling with the accused. We did not have any kind of dispute with him. It is a fact that I have not stated before the IO that the accused confessed to have killed my father and led the police to the place of burial of the dead body, and that in my presence the dead body was dug out, and that I could identify the dead body to be that of my father, and that the testes and pennies of the dead body were missing.
So he admits it that he has not stated. Yes.
It is not a fact that the dead body which I have seen is not that of my father, and that in my presence the accused did not make any statement to the IO which led to discovery of the dead body from the Padar fatherland of the accused, and that I depose false.
Okay, just inquest report টা টিকে বাহার করলে। হ্যাঁ। So about this leading to discovery of this dead body, which was in a buried condition, apart from PW1, who else has stated about it?
No one. Not.
No, you must have stated no.
PW5 also, Your Lordship.
No.
PW5 is in fact the main witness to that.
No, because we
Yes,
find
signed.
that this witness admits that no, I have not stated. So any other witness has stated. PW5 you said.
5.
Acha,
PW5
body left.
is the
Let us see that whether he is
PW5 is, who is he? Name?
name
Lord's,
is like Kalindi Charan Das.
Kalindi Charan Das. So he is one of the witness to the 27 also.
Yes.
All right.
please read that portion. Page 51.
I know the accused and the deceased. More than 3 years back, occurrence took place. On a Wednesday, the accused identified a spot to the police, telling that he had buried the dead body of the deceased there. At that time, the police, the doctor, and one executive magistrate were present, besides many villagers, including ward member Kalia Kahar. The police recorded the statement of the accused in my presence. Exhibit 3 is the statement so recorded, and Exhibit 3/1 is my signature. After the recording of the statement, the police asked PW4 and another to dig out the spot. One dead body was disinterred from the spot. It was the dead body of the deceased. The police then made inquest. Exhibit 2 is the inquest report. I have signed on it.
So why did you say no? PW5 has stated about the same.
But let's
Whether it would be acceptable, not acceptable, matter is different. But when we asked you that who is the any other witness about the discovery of the dead body at the instance of the appellant, you said no, it's PW2.
that is
But PW5 has also stated. And okay, complete that evidence of PW5. Yes.
the entire body was looking whitish, but it was identifiable. Then the accused led the police and we witnesses to another place where one spade was found lying. The spot is 3 to 4 carries away from the first spot. The police seized the spade in my presence. Exhibit 4 is the seizure list and Exhibit 4/1 is my signature. Then the accused was taken to his house. There he brought out one kendu stick which the police seized in my presence. Exhibit 5 is the seizure list and Exhibit 5/1 is my signature. One napkin was there around the dead body. One snuff packet was found from such digging. The police has seized the same by the seizure list Exhibit 6 and Exhibit 6/1 is my signature. Kalia Kahar is the other witness to all the above seizure and he had signed on the seizure list in my presence. Then the cross section. I cannot give the date and month of the above incident. At about noontime, the soil was dug. Out of curiosity, I had gone to the spot as I heard that police had come on inquiry. About 1,000 persons had gathered there. Accused house is very near to the fatherland where from the dead body was disinterred. All the seizure leads were signed by me near the spot which was dug out. I cannot say what are the contents of each of the exhibits that I have proved today. The police seized the seizure list. The skin layer over all the limbs of the dead body was found absent. Disinterment took place at about noon. I do not know whom the spade and the stick belonged to. I was not interrogated separately. I do not know if the magistrate present at this spot put signature on the seizure lists, etc., which the police prepared on that day. It is not a fact that I depose falsely.
Okay. Come to the
EW4 also has stated, Your Lordship.
what?
Page 50. He's the person who dug out the
Okay,
body.
please read that.
Page 50, Your Lordship.
Simanchal Pradhan.
Simanchal Pradhan.
Simanchal
Yes.
Pradhan.
Please.
Paragraph 1.
I know the deceased and the accused. About 3 years back, on a Wednesday, I dug a spot within the land of the accused as per direction of the police. The spot was identified the accused. Magistrate and doctor were also present. Myself and Sunanda dug the earth. The dead body of the deceased was found buried underneath. It was identifiable. Cross-examination. The police took me to the spot in a police vehicle. 50 to 60 persons were present at the spot. As it was a market day, the skin layer was found peeled off, but flesh part was found intact on all over the body. I did not sign on any paper. It is a fatherland. We dug knee-deep soil and then found dead body. From the face and the wearing apparels, I could identify the dead body. It is not a fact that I did not dig the soil and that the dead body was not identifiable.
Okay, come to the IOS evidence. SPW 9.
Page 59, Lakshya.
Hmm.
On 27/9/2004, I was sub-inspector of police and posted as OIC Tikavale PS on the PS. On that day at 5 p.m., I received the written report of the informant and registered the case. Exhibit 1/3 is my endorsement with my signature. Exhibit 1/4 is the formal FIR drawn by me. Then during investigation, I examined the complainant and also the scribe of the FIR. I left for the spot and reached at the spot at 6:30 p.m. I examined the accused, I visited the spot and prepared the spot map. Exhibit 8 is the spot map prepared by me and Exhibit 8/1 is my signature. Then I examined the witness Sudam Bhoi. The accused pointed out the place of concealment of the dead body of the deceased. I recorded the statement of the accused by Exhibit 3 already marked. Exhibit 3/2 is my signature. I kept guarding the place pointed out by the accused and returned back to the police station along with the accused for making requisition, for making arrangement of deputation of the executive magistrate and the medical officer. On reaching the police station, I sent intimation to the SP and the CDMO for deputation of the medical officer and and the executive magistrate. On 29/9/2004, after the arrival of the executive magistrate and medical officer, I again proceeded to the spot with them and the accused who was present at the police station had also accompanied us. I had arrested the accused on 29/9/2004 at 1 p.m. at the spot. In presence of the magistrate and the witnesses and the medical officer, the place pointed out by the accused was dug and the dead body of the deceased was removed. I made inquest on the dead body of the deceased. I issued dead body challan and the medical officer present at the spot had conducted postmortem on the dead body at the spot. Exhibit 2 is the inquest report prepared by me and Exhibit 2/5 is my signature Exhibit 9 is the dead body challan issued by me. I examined the witnesses after releasing the dead body of the deceased in favor of his relation. Thereafter, the accused led me to a gadia situated nearby his field, from where the dead body of the deceased was recovered and pointed out. Thereafter, the accused.
Thereafter, the accused led me to a gadia situated a nearby field, from where the dead body was recovered. Evidence that was this paid the dead body for a recovery. He said already.
Anyway, read
Okay,
it.
read it.
Read it.
Thereafter, the accused led me to a gadia situated nearby his field, from where the dead body of the deceased was recovered, and pointed out to a spade which was lying there. I seized the same powder and prepared the seizure list. Exhibit 4 is the seizure list, and Exhibit 4/2 is my signature. Thereafter, the accused led me to his house, where he has stated to have concealed the weapon of offense, brought out a lathi from inside his house, and gave it to me, which I seized and prepared the seizure list by Exhibit 5 already marked. Exhibit 5/2 is my signature. I seized the garment put on by the deceased after the postmortem was over, and prepared the seizure list by Exhibit 6 already marked. Exhibit 6/2 is my signature. I examined the medical officer who had conducted postmortem, and also the executive magistrate on 30/9/2004. I forwarded the accused to court on 27/10/2004. I handed over the charge of the investigate of this case to my successor on my transfer. Then nurse cross-examination. About 20 to 20 days prior to registration of this case, the informant had reported about missing of his father, which fact was entered in the station diary. I had recorded the statement of the accused by Exhibit 3 on 27/9/2004. I had not examined Chhaya Bisoi. The seized article have not produced in the court. Then I had examined Sudam Bhoi.
You have already placed. You come to the next paragraph. Paragraph 7.
I had examined Birendra Pradhan, PW3. He had not stated before me that he was present when the accused gave the statement before me that he had buried the dead body of the deceased in his fatherland, and then the accused pointed out the spot from where the dead body of the deceased was disinterred. The elder brother of the accused was ailing and bedridden, and therefore I could not examine him. It is not a fact that I got the affair scribed as per my instruction. It is not a fact that the accused had not given any leading to discovery statement before me. It is not a fact that my investigation is perfect.
So, even if this PW3, let us say he has not stated first time, but PW2 has been, evidence has been accepted. And apart from that, we find that PW4 and PW5, so also the investigating officer, they have stated that you made the statement, and that statement was also recorded. That is under Section 27 of the Evidence Act. And in pursuance to that, you pointed out a spot. That spot was guarded. Then he sought for requisition of that medical officer and the executive magistrate. They came on the next day, and in their presence, that portion or the land you pointed out, that was dug out and the dead body was found, and that was duly identified by the son. At least PW1 has identified. So this part of evidence that regarding 27, so how do you challenge it? Because the dead body, it was not lying in an open space or accessible to all. It was within your exclusive knowledge that if somebody dog it, nobody knows that there was the dead body. So it was within your exclusive knowledge. So you made that statement, you pointed out, and that was dogged out. So that one aspect is there, that how you meet this particular piece of circumstance or evidence leading regarding section 27 of the Evidence Act. And Mr. Mishra,
Lordship.
this uh, uh, postmortem has been conducted.
Yes.
And what is the opinion of the doctor? Who is the doctor?
It's PW8.
PW8.
Yes.
Page number 56.
Okay. Injuries are there. External injury numbers of tissue points. Neck muscles and so on looks flat and so on. In a transfer manner on the line, causing fracture. Antemortem and homicidal in nature. So external injuries and so corresponding injury na. So either tonti chipa ହେଇକିନି ମରା ହେଇଛି ନହେଲେ ତଣ୍ଟି ଉପରେ କିଏ ଛିଡା ହେଇକିନି ମରା ହେଇଛି ତାକୁ diet of asphyxia resulting, that is in paragraph number 6. This is diet of asphyxia. So say compression of neck, so hard and blunt force रे ହେଇଛି.
No, Lordship, section 27 is not made out as because the main ingredient of the second section 27 is that the accused must be in police custody.
Yes.
But in that case, at that the accused was not in police custody, Lordship.
Please come to the evidence of PW. Custody, do you mean to say that custody means somebody should be arrested?
Yes, Lord.
No.
That is
Who said so? There are a number of decisions that when your movement is restrained, that custody has been defined, that merely because you are formally not arrested, that doesn't mean that you are not in custody so as to satisfy section 27.
Earlier that confusion was there, what you
That has been that has been clarified long since by the, not only by the Supreme Court, our court. There are a number of decisions. So the moment your movement is restrained, you are under the control of the custody. They have interpreted as control. ତେଣୁ ଆପଣଙ୍କୁ ଯୋଉ ମୁହୂର୍ତ୍ତରେ police control ରେ ଆସିଗଲେ ସେଠି ଯଦି ଆପଣ statement make out କରୁଛନ୍ତି ଏବଂ statement record ହଉଛି, ଯାହାର ଯୋଉ statement ବଳରେ ଆପଣଙ୍କର recovery ହଉଛି, then that will be admissible under section. Formal arrest ହୁଏ ତ ଆପଣ ପରେ ହେଇପାରନ୍ତି, ମାନେ as per the arrest memo ହୁଏତ ଆପଣଙ୍କର arrest ଦେଖାଇ ଥାଇପାରେ ଯେ ପରେ ଗୋଟେ timing ହେଇଥାଇପାରେ, recovery time ଟା ହୁଏତ ତା earlier ହେଇଯାଇଥାଇପାରେ ହେଲା. Maybe in this case ଆମେ ଦେଖିବା, suppose inquest report may be 3:30, ତ arrest ହୁଏତ 4:30 ରେ ହେଇପାରେ, arrest memo time. But the evidence of the IO, it shows that you are totally under control, you are in the company and you are totally under control. So that confusion should not be there.
My humble submission is, Lordship, on 24 on 24 I have stated, but on that date my statement was not recorded.
On 24 your
Yes.
statement was not recorded.
Yes, Lordship.
On
My
24.
statement was recorded on 27 after my arrest.
No, just a minute. Let us see that. The IO says, let us come to that part again. Paragraph 3. No, 3 question. To upon PW 9. I
Yes,
examined the witness Sudham, believe that. Then this ତା ପୂର୍ବରୁ କହିଦେଇଛି, ଆପଣ ଦେଖନ୍ତୁ paragraph 2 ରେ ଦେଖନ୍ତୁ, 2 ରେ କହିଲା I left for the spot, reached at the spot at 6:30. କୋଉ ଦିନ, ମାନେ ଆପଣଙ୍କର FIR ହେଇଛି
That is on
27/9/2004. ତ 27/9/2004 ଦିନ ସିଏ 6:30 ରେ ସ୍ପଟ ରେ ପହଞ୍ଚିଲା ଏବଂ obviously 27/9/2004 ରେ ସିଏ accused କୁ examine କରିଛି ବୋଲି କହୁଛି, right? ତେଣୁ recording of the statement ର ପ୍ରଶ୍ନ ଆସିବ ତାପରେ, ତା ପୂର୍ବରୁ ତ ଆସିବନି. Now I visited the spot and prepared the spot map. Exhibit 8 is the spot map. Prepared so and so. अच्छा ठीक है, exhibit 8 टा ठीक बाहर कर ले, देखिए दवा simultaneously. spot map ଅଛି ପରା ତାପରେ serial ହେଇଥିବ ଏଟା 3
Page 64.
Yes, page 60.
ହଁ ସେଗୁଡା good so ଉପରେ ଦେଖନ୍ତୁ time ପଡିଛି paragraph number 6 ରେ this was prepared on 27/9/2004 at 7 p.m. ସନ୍ଧ୍ୟା 7ଟା ବେଳେ ଏଇ ଯୋଉ ସ୍ପଟ ମ୍ୟାପ ଟା ପ୍ରିପେୟାର ହେଇଛି ବୁଝିଲେ 6:30 ରେ ସେ ସ୍ପଟ କୁ ଗଲେ ସେଇଦିନ 7ଟା ବେଳେ ସ୍ପଟ ମ୍ୟାପ ପ୍ରିପେୟାର ହେଲା ରାଇଟ
Yes, Sakshi.
now next line ପଢନ୍ତୁ I examine the witness Subhas Bhoi is PW 2 right
Two.
ହଁ ତାପରେ the
Sudam Bhoi,
sorry Sudam Bhoi is PW 2 ହଁ the accused pointed out the place of concealment of the dead body of the deceased ତାପରେ I recorded the statement of the accused. So obviously this is a statement which was recorded on 27/9/2004. 27/9/2004. Okay. I kept guarding. ସେଇଦିନ statement ପାଇଗଲା ଏବଂ
Which he said that I have examined accused.
ହଁ
Earlier he has said that I have examined accused. That is was the statement recorded.
ହଁ ବଟ୍ ସେଦିନ ସେ ଜାଗା ବିଷୟରେ ମଧ୍ୟ ତାଙ୍କୁ ସୂଚନା ଦିଆଗଲା
ଦିଆଯାଇଥିଲା କିନ୍ତୁ
ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଲା ଏବଂ ଜାଗା ବିଷୟରେ ତାଙ୍କୁ ଦେଖା ହେଇଗଲା ଯୋଉଥିପାଇଁ କି ସେ କହୁଛି ଯେ I kept guarding the place pointed out by the accused and returned back to the police station along with the accused for making requisition
yes
for making arrangement of deputation of the executive magistrate and medical officer. On reaching at the police station, I intimated SP CDMO for deputation of so and so
then he
on
arrested
on 29/9/2000 after arrival of the executive magistrate and medical officer I again proceeded to the spot with them and the accused who was present at the police station also accompanied then arrested the accused on 29/9/2004 at 1 p.m. at the spot ଏଇଟା ହେଲା in presence of the magistrate witnesses medical officer place was pointed out it was dog dead body was removed I made the inquest now inquest report को आसନ୍ତୁ ଆଉ ଥରେ ଟିକେ inquest report ଆସନ୍ତୁ ହଁ inquest report ର time ଟା ଦେଖନ୍ତୁ inquest report time ଦେଖଉଛନ୍ତି 2 p.m. 2 p.m. ରୁ 4 p.m. ହେଲା so ସେଟା ହଉଛି 29 ତାରିଖ ଦିନ so ଏଇ ଯୋଉ time ଟା ହେଲା 29/9/2004 2 p.m. ରୁ 4 p.m. ଏଇ ସରିଲା ପରେ ଆପଣଙ୍କୁ ଆରେଷ୍ଟ ଦେଖେଇଛି so issue thereafter
ତା ପୂର୍ବରୁ କରିଛି 1 p.m.
I arrest acha 1 p.m. ହଁ 1 p.m. ରେ arrest କରିଛି ତାପରେ 2 p.m. ରେ ଗୁଡାକ ଇଏ ହେଇଛି so at the your submission that when the accused pointed out that place on a day before that is on 27 by that time he was not in custody or not arrested so again that comes to that decision that what is the meaning of custody whether it requires formal arrest or it is when
Restriction.
the restriction movement control le asigala pare habo that has been already it's a constitution based decision that was because of the divergent view that was referred and that was been answered that no custody means is a control so you cannot say on that on 27/9/2004 the accused was not under the restraint or on the control of the so sei circumstance re ଯଦି statement make out କରୁଛି merely because ତାର recoveryଟା ମାନେ ଯୋଉଟା ବା actual dog out ଟା ଟିକେ ଡେରି ହେଇଗଲା ହେଲା
because of the arrangement and
because
executive magistrate.
obviously ତାଙ୍କର ସେଇଟା ମାନେ ଆପଣ ଯଦି recovery ହେଇସାରିଲା ପରେ appellant ର statement ଆସିଥାନ୍ତା that would not have been there କାରଣ ତା ଦେହରେ କହୁଛି that so much of statement which is relevant for the discovery of that fact. That means ସେତିକି ହିଁ admissible ହବ as per 27. ତେଣୁ ଏଠି ଆପଣଙ୍କୁ ସେ spot ଟା ସେ already 27 ତାରିଖରୁ ଦେଖେଇ ଦେଇଛି, ସେଟା on guard ରହିଛି, ଏବଂ ତାପରେ just ଗୋଟେ ଦିନ ପରେ because of this arrangement it was dug out on 29. So this would be admissible under.
And also another point of catching is the statement and the leading to discovery must be in contemporaneous to the statement. That is how 27th it has been recorded, then he led. So it is in contemporaneous to the statement that he led the witness and the police.
And Lordship, my humble submission is that he only spotted that spot. That doesn't mean that he killed that person.
No,
No.
that comes later.
That is
That part.
we
We
are
are now in 27.
we are now on 27. ଆମେ 20
Admissibility of 27.
there are number of decision that खाली 27 रो evidence हेले जणकु 302 रे conviction हेई परियो कि नाही. Again that
Absolutely
depends
not.
upon several factor. 27 टारे कोन टा मिलिला, को जगह रु मिलिला, ता धेरे मध्य डिफरेंस अछि. आपण गोटे वेपन टे मिलिबो 27 ने खाली ताकू बस बेस करी परिबनी. But ethi something different. Ethi the dead body was in such a position that it was within your exclusive knowledge. If we accept, then you are to explain जे आपणको नॉलेज रे केमती आसिला डेड बॉडी टा सेठी पोता आइची, ता निज जमी रे गात खोलाइकिनी पोता आइची, ए सूचना टा आपणकर नॉलेज रे केमती आसिला. बर्डन ऑफ प्रूफ लाइज ऑन यू दैट हाउ इट कम. जदि आपण गोटे प्ली नै थाते जे मु राम देखुथिली एमती जाईथिली, मु देखिली somebody was digging and ता भितरे रखिदेला ଏବଂ ମୁଁ ଭୟରେ କାହାକୁ କିଛି କହିନଥିଲି, ସେଇଥିପାଇଁ ମୁଁ ଇଏ ଦେଲି, ବାକି ଯୋଉ ପୋଲିସ ଲେଖିଛନ୍ତି ମୁଁ ମାରିକିନି ପୋତିଲି ସେଟା ଠିକ ନୁହେଁ. ଗୋଟେ explanation ଦେଇଥାନ୍ତା. What explanation you have given on the when the questions on PW2, on the questions on PW4 and PW5, so also the IO has been put to you in the accused statement that at your instance, on the basis of your statement, the dead body was recovered. What is your reply? What explanation you have given? If we accept, we are letting that ଆମେ ଏଟାକୁ accept କରିବୁ ଯେ ଆପଣଙ୍କ instance ରେ ଆପଣଙ୍କ ଜମିରୁ dead body ଖୋଳା ହେଇକିନି ମିଳିଲା. ତେଣୁ ଏଇ circumstance ରେ ଯୋଉ ସାକ୍ଷୀ ମାନେ ଦେଇଛନ୍ତି ଆମେ ଧରିବୁ ଯେ ଏକା ବିଶ୍ୱାସ ଯୋଗ୍ୟ ବୋଲି. Now what is your accused statement? Except ମିଛ କଥା ଛଡା ଆଉ କିଛି କହିଛନ୍ତି?
No.
ଏମୁଣ୍ଡରୁ
Question-
ସେମୁଣ୍ଡ ଯାଏ ସବୁ ମିଛ,
Absolutely ମିଛ.
ସବୁ ମିଛ.
Question 36 and 37. Your Lord.
Hmm.
ହଁ ମାନେ
Page
So
40.
he has taken
Ah.
only one thing, the denial.
deny.
That's all.
Denied, yes.
These Mr. Mishra, ଏଇ
Lordship.
ଯୋଉ ସମସ୍ତଙ୍କର ଏଇ ଯୋଉ statement ଗୁଡାକ ତାଙ୍କୁ confront ହେଇଛି ତ, because it is to be put to him, କାରଣ PW2,
Yes,
4 and 5
Yes,
they
yes.
are ହଁ ସେଇଆ
PW2, PW3, PW4,
ହଁ
5,
PW4 ଅଛି, ହଁ PW5 ବି ଅଛି.
specifically it has been done.
ହଁ
Question number 6, Your Lordship. At
question
page
number
36.
6. So and so that you buried the dead body, laid the pot, so and so pointed out this spot Mitchum. Suppose, Mr. Mishra, some doubt is cropped up regarding this extrajudicial confession. Kind of the motive part, if it is missing in the FIR, which was lost much after the মানে when the because 3 দিন 4-5 দিন পরে ତାକୁ କୁହାଗଲା ତାର ପାଖାପାଖି 2-3 ସପ୍ତାହ ପରେ ସିଏ FIR ଦେଇଛି ଯଦି ଆପଣଙ୍କର PW2 ର କଣ କହିଲା ଯେ 5 ଦିନ ପରେ ମିସିଂ ହେଲା ମିସିଂ ର ସିଏ ଜାଣିନେଲା ଏଇ ବିଷୟରେ ତାକୁ ସେଇ ଯୋଉ କଥାଟା କହିଲା ଯେ ଯିଏ ଗୁଣି କରିଥିଲା ତାକୁ ପକ୍କା ହେଇଯାଇଛି and ସେ ଗୁଣିଆ ବିଷୟରେ ପଚାରିଲା ସେ କହିଲା ଏଇଟା ହଉଛି ସେ ଗୁଣିଆ ହଉଛି Sanatan. Mane this who had witchcraft to Gunia, he told that the deceased.
Dadi. Parmeshwar.
Dadi. Acha. এই যে পার্টটা যদি because of acha, then why now the thing is that if this information was available to the son of the deceased within 5 to 6 days, and he had already intimated the police. When he intimated, just see that
27.
no. 27 is the FIR. Prior to that, he had given a missing report.
Person's report, Your Lordship.
हाँ, स्केबे सेटा देला.
24/9/2004.
बुड़ी कोड सेटा अछि.
That is on FIR, Lordship.
Hmm?
31, page number 31. That is
हाँ.
the statement.
जदि आपण कोठी हाँ 24/9 रे तामाने 24/9 पर्यंत ताकू एटलिस्ट PW2 कहि नथिला.
But the at page 61, the IO is stating that about 22 days prior to registration, the missing person
Missing
report was
report.
given.
क्या देखिले कोठी?
Page 61, Your Lordship, may kindly
Yes.
read.
Yes, stated so.
61.
Paragraph 5.
And station diary entry was made. Anyway, we
Yes.
have to see the station
हाँ,
diary entry.
स्टेशन डायरी एंट्री केबे डेट ता सेइथु तो जणा पड़ जियो एक्चुअल डेट रो. What is the date of station diary entry?
That we have to see.
That is marked, na?
Master case diary.
नहीं, okay. अच्छा, केस डायरी लिखा ही नहीं.
Let's see, that is revealed in the deposition of the PW1.
हाँ.
That 3 years and a month back, my father left home at 7 a.m. to take
No,
water
the
to
date
our
of
wedding.
deposition.
Yes, Lordship. After that, till evening, he did not return. We went in search of him, but could not get no trace. We searched for 21 days. That means, Lordship, there was no FIR has been lost.
No,
FIR not, missing report.
एबरा मिसिंग रिपोर्ट गोटे दिया छि केस जोटा कि आपनकर FIR भी उल्लेख अछि एवं आईओ मध्य कहउचंती जे मिसिंग रिपोर्ट दिया हैतला से जो वी जस्ट वांट टू नो दैट एंड एवं केवल दिया ही नथला मिसिंग रिपोर्ट बल रे गोटे स्टेशन डायरी एंट्री मध्य हैतला दैट इज द whether it is there in the case diary.
किंतु लॉर्डशिप से इठी कहउचंती कि एफआईआर रे मो बापा परमेश्वर प्रधान गत गुरुवार दिन अर्थात 2/9/4 तारिख सकाळु प्राय 7 घंटिका समय आम घरु बाहरी हातरे गोटे कुड़ी धरी आम बिलरे पानी बुलेवा पई जाइथिले. उक्त दिन राति सुधा मो बापा घरकु न फेरिबारु मु आम गाँर आखपाख जागा एवं बंधु बांधवଙ୍କ घर मानकरे खोजिबारे तांकर कोनोसी खबर पाइली नै. तेणु मु गत 24/9/4 तारिखरे एही विषय टिकावाली थाना रे जणा करी.
No, no, see, ता evidence ru jana purji clear. Jo apana, you are right that from the evidence of PW1, it appears that the missing report, seta FIR madhya achi, je 24/9,
That's it.
to 24/9/2004, re missing report diya gala. But now what Mr. Mishra pointed out that the IO said something different. IO said in paragraph number 5 of page 61 that 20-22 दिन पूर्वर registration हवा पूर्वरु informant report कला about the missing for which station diary. So actually we want to know that
Any such entry is there.
such entry is there, and if that, what is the date of entry?
That is, I think, Lordship, that is reflected in just below the FIR. That is exhibit 1 by 1.
Below the FIR.
Just Lordship, PMJJ.
Koda.
No, Lordship, that is 2005.
That is regarding this
2005.
juvenile.
Pardon, Lordship.
The FIR is silent on that reference because
No, FIR କୁହାଯାଇଛି ନା ମୁଁ 24 ତାରିଖ ଦିନ ଥାନାରେ
no,
ଜଣେଇଥିଲି।
in the reference part I'm citing. There's a station diary reference part.
ନା ଷ୍ଟେସନ ଡାଇରୀ ଏଣ୍ଟ୍ରି ଏଇଟା ହେଇଥାନ୍ତା, ଇଏ ମାନେ ଆପଣଙ୍କର FIR ହେଲେ ବି that is also reflected in that station diary, ବୁଝିଲେ ନା? ଯାହା ହଉଥିବ ସବୁ ସେଟା ଗୋଟେ ରନିଂ ଟାଇପ ର ଥିବ, କିଏ କୁଆଡେ ଗଲା ପେଟ୍ରୋଲିଂ କରିବାକୁ, ସେଇଟା ତେଣୁ ସେଠି ମଧ୍ୟ ଆପଣଙ୍କର ଏଣ୍ଟ୍ରି କଲା ମାନେ ଇଏ ରହିବ, ସେ ନମ୍ବର ମଧ୍ୟ ଆଦେହରେ ଉଲ୍ଲେଖ କରିବା କଥା। we are not on that, ଆମେ କହିବା କଥା ଯୋଉ ମିସିଂ ରିପୋର୍ଟଟା ହେଲା କେବେ ହେଇଥିଲା ତାର because as per the statement of this IO, one station diary entry was made, so that case diary ta ଟିକେ ଦେଖି record ନଜର ଯଦି ପଡିବ, case diary ଟା
He's saying so, but here it is written forwarding report. Was missing from his house, and in this connection, he reported missing report at PS on 24 minutes. So prior to that, what is setting?
Yes, Mr. Mishra is right. In the forwarding report, even he is mentioned that 24 ନରେ ଦିଆ ହେଇଛି missing report. ତେଣୁ ଆଇଓର statement ଯୋଉଟା ଏଇଟା
stationary entry ଅଛି, that is to be verified. I don't think that is there.
ସେ ଯୋଉ କହୁନାହାନ୍ତି ଯୋଉ ଆଇଓର statement 20-22 ଦିନ ପୂର୍ବରୁ, ଏଇଟା ଗୋଟେ ସେମିତି ବୋଧେ ସେଟା ନୁହେଁ ଠିକ,
because nothing comes on record prior to 24th anything has happened.
କାରଣ ସିଏ ବି କହୁଛନ୍ତି ଆମେ ତ 20-22 ଦିନ ଧରି ଖୋଜିଲୁ, 24 ତାରିଖରେ ଆମେ ରିପୋର୍ଟ ଦେଲୁ। ଏଇଟାର ଇମ୍ପୋର୍ଟାନ୍ସ ଏଇଥିପାଇଁ ବଢି ଯାଉଛି, ଯଦି ତାକୁ 3-4-5 ଦିନ ଭିତରେ ଜଣା ଥିଲା, କାରଣ 5 ଦିନ ଭିତରେ PW2 ଜାଣିନେଲା, PW2 କହୁଛି ମୁଁ ତା ପରଦିନ ଅର୍ଥାତ୍ ନେକ୍ସଟ ଦିନ ଅର୍ଥାତ୍ 7 ଦିନ ମ୍ୟାକ୍ସିମମ୍ ହଉ, 7th day ଦିନ it was within the knowledge of PW1. If PW2's version is correct that there was some kind of extrajudicial confession, then it was within the knowledge that ତାକୁ ତା ବାପାକୁ ମରା ହେଇଛି, ମାରିଛି କିଏ ନା ଆପେଲାଣ୍ଟ ମାରିଛି ଏବଂ ତାକୁ ମାରିକିନି କୋଉଠି ଗୋଟେ ପୋତିଛି, ଏତିକି ଅଛି। ତ ମିସିଂ ରିପୋର୍ଟ ପୁଣି 24 ତାରିଖ ଦିନ କେମିତି ଦବ ସିଏ? that creates doubt about the evidence of PW2. The necessary part is this, that had it been there was any information with PW1 that any extrajudicial confession was made by the appellant to the to PW2 and he became aware of it because PW2 disclosed before him, he would not have lost the missing report. Se jaitanda straight खोजिଥାନ୍ତା, ଆଉ ବାପାଙ୍କୁ କାହିଁ ଖୋଜୁଥାନ୍ତା ସେ 22 ଦିନ ଧରିକିନି? ଇଆଡେ ସେ ତ ଜାଣି ସାରିଲାଣି ଯେ ମୋ ବାପାକୁ ଏଇ ଲୋକଟା ମାରିଛି, ତାକୁ ନେଇ କୋଉଠି ପୋତିଛି ଏବଂ ସେ ସିଧା ଯାଇଥାନ୍ତା ପୋଲିସ। What is the reason for getting delayed in lodging the FIR at least?
Lordship, the version of PW1 is not corroborative with the version of PW2 so far as the date of PW1 getting the knowledge of the fact.
Right.
Because PW1 has stated that in paragraph 2 that we searched for 21 days. Thereafter, PW2 told me that
21 days पर्यंत PW1 रो knowledge रे किछि थिला कि जे बापा
PW1
it was
not there.
But PW2 रो आपण को साखी ना, ये तो तांको डिफेंस साखी नो ना, ଆପଣଙ୍କର ଗୋଟେ ସାକ୍ଷୀ କହୁଛି ଯେ 5 ଦିନ ପରେ ମୁଁ ଏମିତି ଇଏ କଲା ମୁଁ ଗଲି ମୋ ପାଖରେ ଏଇଆ କହିଲା ମୁଁ ତାକୁ ଆଜି ତାର ଠିକ ପରଦିନ ଆସିକିନି କହିଦେଲି। ଏଇ ଯୋଉ ପାର୍ଟଟା ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ହିସାବରେ ଆପଣ ୟୁଜ କରୁଛନ୍ତି। But is it believable? But particularly when motive part is also not there. जो यही कारण पाई मार्ची कौन ना गुणिया पाई एफआईआर देला 27 तारीख रे से गुणिया पाठ मध्य नाही एक्स्ट्रा जुडिशियल कन्फेशन भी नाही माने जानिबार डाउट
इनफॉर्मेटिव नहीं
हाँ आ गुणी जानिथिला बेली भी मध्य डाउटफुल होची जे एक्स्ट्रा जुडिशियल कन्फेशन विषय रे ताकू पीडब्ल्यू2 आसी कहिथिला ए विषय रे मध्य डाउट क्रिएट होची जेहेतु से मिसिंग रिपोर्ट गोटे दउची 24 तारीख रे
Yes, the missing report part, my submission is that because for 21 days he was searching. After that, he has given the missing report.
No,
Perhaps.
छाड़ी on total we are harping on that extrajudicial आपण PW2 रो एविडेंस टा जे ताकू गोटे extrajudicial confession appellant ता पाखरे कहितिला जोटाकू सी ता परदिन आसिकिनी डिस्क्लोज करथला एइटा बिलीवेबल हबो की particularly in view of the evidence on record that for 22 days they were searching and missing report was lodged on 24th. Sei gutako amu ଟିକେ ବୁଝାନ୍ତୁ।
Lordship, they are rustic villages because
ଆପଣ ଗୋଟେ ରିଜନେବଲ ୱେରେ ଆମେ ଇଣ୍ଟରପ୍ରିଟ କରିବା ମତେ ନିଜକୁ ସେ ପୋଜିସନ ଇଏ କରାଯାଉ ମୁଁ ହଉଛି ଏତଲାକାରୀ ହେଲା ମୋ ପାଖରେ ଇନଫରମେସନ ନାହିଁ ମୋ ବାପା କୁଆଡେ ଗଲା ଯାଇଥିଲା ବିଲକୁ ପାଣି ମଡିବା ପାଇଁ ଫେରିଲାନି ମୁଁ ତାକୁ ବିଭିନ୍ନ ଜାଗାରେ ଖୋଜାଖୋଜି କରୁଛି ହଠାତ୍ 4-5 ଦିନ ପରେ ମତେ ଆସିକିନି ଜଣେ ବହୁତ କ୍ଲୋଜ ଲୋକ ମତେ କହିବ ଯେ ମତେ ସେ ଅମକ ଲୋକ କହିଲା ଯେ ସିଏ ତ ବାପାକୁ ମାରି ଦେଇଛି ତାକୁ ମାରି କୋଉଠି ପୋତିଛି ମୋର ରିଆକ୍ସନ କଣ ହବା କଥା what would be expected from a reasonable person in such circumstances whether she will go on again on searching and missing report ଦବ ଆଉ ତାର 15 ଦିନ ପରେ ନା ସିଧା ଯିବ ଥାନାକୁ ଏ କଥା ଯଦି ତାକୁ ଜଣା ଥିଲା 5 ଦିନ ପରେ ଯେ ଏଇ ଟାଇପ ର ଗୋଟେ ଲୋକ ଆସି ତାକୁ କହି ସାରିଲାଣି what would be his next course of action ତେଣୁ ସେଇଥିପାଇଁ କୁହାଯାଏ ଯେ ଏଇଥିରୁ ଯଦି ଆମେ ଦେଖିବୁ ତାହେଲେ ସେଇ ଜିନିଷଟା ଘଟିଛି ତାର ଯେ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଜଣେ କରିଛି ଯୋଉ ଇଣ୍ଟିମେସନ ଟା ଆଣି ଦେଇଛି that creates doubtful ସେଇ ବିଷୟରେ ଆମେ ପଚାରୁଛୁ ଯେ what is your submission?
my submission is that so far as the doubtness part is concerned, just because of this fact, we cannot render the whole testimony as inadmissible, Your Lordship.
whole testimony we are not
we are not
harping-
going on that we are not going on that
Because
there is little prevarication with respect to that now again you can say that the FIR is not a substantive piece of evidence number one number two it will not have a detail of the
yes, not an
Uh,
encyclopedia.
encyclopedia but such information which appears to be eventful how can a informant while he is narrating other incident he is forgetting this because this is a very important part of the information that I killed your father and buried him here or he has been buried somewhere this is a very important thing amidst all other narration he could not have forgotten this
Yes, he could not have, should not have. Any
Yes,
reasonable
yes.
man will not.
So that is why we
But PW1's version is that he got to know the news after 21 days. Now there is a slight discrepancy in
yes,
that.
that is what I am saying.
So they are testifying. They have testified after a lapse of 3 years and 1 month, Your Lordship. So that also has to be taken into consideration because after such a long time, people often forget small details, facts, dates, etc. Time because they're rustic villages and it has been held in many cited
No,
Yes, yes.
what we are going a step further ଆମର କହିବା କଥା ଯେ ପର୍ଯ୍ୟନ୍ତ ତାକୁ ମିସିଂ ରିପୋର୍ଟ ସେ ଦେଲା ସେ ପର୍ଯ୍ୟନ୍ତ ତା ପାଖରେ କୌଣସି ଇନଫରମେସନ ଆସି ପହଞ୍ଚି ନଥିଲା PW2 ପାଖରୁ ସେଇ ଯୋଉ ଇନଫରମେସନ ପହଞ୍ଚିଛି ସେଟା ମିସିଂ ରିପୋର୍ଟ ଦେଲା ପରେ ତାକୁ ପହଞ୍ଚିଛି ତାପରେ ସେ FIR ଦେଇଛି just think over it
Yes, that is
that
what,
is consistent but prior to that is not consistent that is the whole thing where
yes, the date part, Your Lordship. That is what is creating confusion,
Right,
Your
right.
Lordship. But the
ତେଣୁ
substance is still there in PW2's
ମିସିଂ ରିପୋର୍ଟ ପରେ ଇନଫରମେସନ ପହଞ୍ଚିଛି ଯୋଉଥିପାଇଁ ସେ FIR ଦେଇଛି
Lordship.
ରାଇଟ୍
Lordship.
ମିସିଂ ରିପୋର୍ଟ ପୂର୍ବରୁ ଇଏ ଦବା କଥା ତେଣୁ ମିସିଂ ରିପୋର୍ଟ ଏଠି ଆମେ ଯାହା ଭେରିଫାଇ କଲୁଣି ଡକୁମେଣ୍ଟ ରୁ ଏବଂ PW1 ର ଏଭିଡେନ୍ସ ରୁ आईओ मध्य ता फॉरवर्डिंग रिपोर्ट रे एक्यूज लिखिछि जे सी रिपोर्ट पाइला 24 तारिख दिन ए जोटा कहि
So
दै
that
जे
is a misstatement.
Yes.
हाँ misstatement, right. Now let us one case that if this is the little doubt about this extrajudicial confession, but whether the other thing, if we found that it is consistent and whether the conviction would be sustained or not.
Lordship,
27 ने गोटे केस रे हला आपण नेकिनी ए टाइप रो जागा देखैले जो जागा रे आउ कार नॉलेज नथिबो सेठू डेड बॉडी टा मिलला तेणु एठी आपण ऑथर ऑफ द क्राइम हेबे ना खाली 201 रे हेबे.
Lordship, just one doubt is there, sir, that in the statement of that is PW 9, Lordship.
Nine.
Examine the witnesses Sudam Bhui. The accused pointed out the place of concealment. That means, Lordship, मते जदि जणे एबे कहबो कि तू मारिचन, immediately I pointed out that spot.
How you'll point it out?
If you do not know.
If you do not know, how do you point out? And from that place the recovery is material.
Yes, Lordship.
ଆପଣଙ୍କର ଶୁଣନ୍ତୁ ଆପଣଙ୍କର ଯଦି statement ବସି ଆପଣ ଯୋଉ spot ଟା point out କଲେ ନା ସେଠୁ କିଛି ମିଳି ନଥାନ୍ତା, matter is something different, but ଆପଣ ଯୋଉ ଜାଗାଟାକୁ point out କଲେ ସେଟା guard ରେ ରଖାଗଲା ଏବଂ ତା ଦେହରୁ ଖୋଳା ହେଇକିନି magistrate ଏବଂ ଡକ୍ଟରଙ୍କ presence ରେ ସେ ଜାଗାରୁ dead body ମିଳିଲା. So that is that all this makes a chain that ଆପଣ statement ଦେଲେ spot କୁ ଦେଖେଇଲେ ସେଇ spot ଖୋଳା ହେଲା सेठू डेड बॉडी टा मिलला डेड बॉडी टा होजी गोटा होमिसाइडल डेथ.
Lordship, ମୁଁ ଖାଲି statement ଦେଇଥିଲି कि ପକା ଯାଇଛି.
हां
What's my statement, Lordship?
Hmm.
Statement is that is ସନାତନ ଏଥର ଭଲ ହୋଇଯିବ, ଯିଏ ଶୁଣି କରିଥିଲା ତାକୁ ପକା
No, that
ହେଇଛି.
is
No, no,
the state.
that's-
That is not the state.
that is
Statement
not.
in 27.
Statement is 27.
27.
Yes,
That is
Lordship.
recorded on that is been also marked, I think. It is marked
Exhibit 3.
exhibit 3.
That will see.
से entire statement भी जीवनी से गोटे portion टार
So
relevance.
what he has stated there.
Exhibit 3 टा ଟିକେ देखि दवा ଟିକେ देले.
Yes.
जो मुंह मार देली ताकू नै एगुडा को इनएडमिसिबल सेही जो पोर्शन ने
से जो मु ताको एथर रागी करी
हां
केंदु गुडा
सो सेगुडा को नुई एई आसे रेलेवेंसी हबो.
मो दादी मरि जिबा परे तार मृतदेह को मु आम घर पाख गोटे खाली घरे लुचाई रखी उक्त दिन राति एवं मु मोर पुत्रा बड़ भाई प्रधान उक्त मढ़ को बोही नहीं आम घर पाख मोर निज बिलरे गात खोली चपाई पोती देली. आम घर मोर निज बिलरे गात खोली पोती देली. दिस इज द वन.
एई पर्टिकुलर आ बाकी से उडा छाड़ दियन एमती मारली सेमती मारली ताको आनी नुचेइतली ये कली
2025.
हां उडा 25 रे जीवो बट एई जो पोर्शन टा consequent upon that statement
and another person मोर दादी धरथिबा कोडी को मु नै गोटे धान
हाँ,
बिलरे पकाई दी.
सेटा again that is
These are the
recovery of that weapon of offense. तेणु weapon of offense dead body has been recovered at your instant and the recovery is from such a place that it would be within your exclusive knowledge. I still remember when I was arguing a case before the division bench in Honorable Chief Justice Court. That was B.L. Hansaria was the Chief Justice in 1992 or 93. He type wrote a case thila. But his lordship was the district judge. And he
in the Brugad.
हाँ ये गोटे केस रे आउ किसी एविडेंस नथला से तार से लोकटार स्त्री he was missing and the dead body was buried in the bedroom itself हला बेडरूम ऊपर बरीड हेकिनी ताको पूरा प्लास्टरिंग हेकिनी से लोक बा सेठी बसिकिन आनंद रे म्यूजिक फ्यूजिक सुने.
That is the house where the district judge residence.
हां सो सेही पोजीशन नु आउ किछि एविडेंस नाही only 27 and The conviction was me a question that this is the. So what has happened in that case? That's a different matter. But so 27 ର ଦରକାର ଯେ ଏଇଟା ଏଇଟା ଆପଣ ହଁ ଗୋଟେ ବାହାରେ ପଡିଥାନ୍ତା ଗୋଟେ ଡେଡ ବଡିଟା ବାହାରେ ପଡିବା ଆଉ ଗାତ ଖୋଳିକିନି ଗୋଟେ ଗାତ ଖୋଳିକିନି ବାହାର କରିବା there is difference in it.
Under normal circumstance, could it be possible by anyone, including the investigating agency, to find out the body? Then it comes the exclusive knowledge of the person. Had he not disclosed, probably it would not have been possible in normal course, either for the investigating agency or anybody else, to find out the body.
Lordship, my humble submission
Yes.
is, without arresting me, can you
Again, you are
Again,
coming to
you
that.
are coming to
You
that.
are,
You
you
are
are,
my submission is, mate jane police arrest karibane, and if I have committed that mistake, can I reveal that in front of the police, Lordship?
that is
That is
settled.
it.
That is settled. Don't go to that aspect. That is settled.
Because-
Can you reveal means?
Question is whether you have revealed or not. Can he
Can he,
reveal or-
cannot is not the question. He has revealed.
Yeah, because of the if you have brought out something in the cross examination that no, he has not made that, it's a fabricated version,
Then it's
that's a matter different. But ଯୋଉମାନଙ୍କର presence ରେ statement ଦେଇଛନ୍ତି, ଯୋଉମାନଙ୍କର presence ରେ leading to discovery ହେଇକିନି dead body ହେଇଛି, ସେଇଭଳିଆ witness apart from the IO, 3 other witnesses,
Are there?
that is 2, 4 and 5.
Yes,
There.
Lordship. 5 is coming. Let's kindly answer the 5. That is page number 51.
Hmm.
I cannot, that is the in cross-examination. I cannot give the date and month of the above incident. At about noon time, the soil was dug.
Yes.
Out of curiosity, I have gone to that
Yes,
spot.
that means he is still independent.
Yes.
Yes, Lordship.
His independence is still restored.
That means he didn't know about that. Whether
Exactly. Exactly. He
Yes.
need not be called.
Yes,
He is
Lordship.
a chance witness that
Yes,
way.
Lordship.
And an evidence through a chance witness in such matter has to be given primacy.
That means my humble submission is that, Lordship, that means he didn't know about that. That accused person had revealed that is the place, and you
No, ସେଇଟା ଆପଣ ଶୁଣନ୍ତୁ, ତାର ଦିଟା ଫେଜ ରେ ରହୁଛି। ଆପଣ ଦେଖନ୍ତୁ ସେ ଚିଫ କୁ ଆସନ୍ତୁ, ୱେଡନେସଡେ ରେ ସି ଆଇଡେଣ୍ଟିଫାଇ କରେଇଦେଲା ସ୍ପଟ କୁ, ଆଉ ଥରେ ପଢନ୍ତୁ ତାକୁ ଚିଫ ଏକ୍ସାମିନେସନ ହେଲା। ଡେଡ ବଡି on the so identified a spot telling that he had body. At that time, the police so and so, besides many other. That means it is subsequent to that. Actually, statement record ହେଇଛି କେବେ?
27 ରେ।
Statement ଦେଖିବା 27 statement record
27
କେବେ?
ରେ sir।
ହଁ ନାଇଁ 27 statement 29 ତାରିଖ record ହେଲା କି?
ନାଇଁ sir 29 ରେ ତ ଇଏ ହେଲା, arrest ହେଲା, 27 ରେ record ହେଲା।
ନା ସିଏ 27 ରେ କହୁଛି ଯେ, but 27 ର statement ରେ ଦେଖନ୍ତୁ ତଳେ endorsement ଅଛି 29 ତାରିଖରେ, recorded by me on 29/9/2004. So ଗୋଟେ doubt ଅଛି।
29
ତଳେ ଲେଖାନ୍ତି recorded by me, IIC sign କରିଛି ଯୋଉ କୃତିବାସ ପ୍ରଧାନ ର signature ରହିଛି, date ପଡିଛି ତା ତଳେ clear date 29/9
Oh, sir, this is reference to ଆଜି 29 ନ।
ସେଠି ବି ଅଛି, ତଳେ ବି ଅଛି 29 ନ।
ଠିକ ଅଛି, yes,
State-
all right.
statement
If at all,
ହଁ
if at all, after the arrest he has made the, no issue. What is that?
statement ର time ଦେଖନ୍ତୁ ଆପଣ, statement ଟା ହଉଛି ଯାହା ଜଣା ପଡୁଛି 29/9/2004 ଦିନ
Yes.
12:30 ରେ ହେଲା। 12:30 ରେ statement record ହେଲା ଏବଂ
ଗୋଟେ ବେଳେ start
ଗୋଟେ
ହେଲା।
ବେଳକୁ ଇଏ ହେଲା ଏବଂ ତାପରେ ଇମ୍ପ୍ରେସ
ବେଳେ
ହେଇଛି
impressed।
2ଟାରୁ 4ଟା ଭିତରେ, ମାନେ ସେ ଯୋଉ ଡେଡ ବଡି ଟା ମିଳିଛି। ତେଣୁ ସିକ୍ୱେନ୍ସ ହେଇଛି
Rather,
ସେ
your query to the effect that on 27th, if the statement has been recorded, then this witness was not present according to you.
Yes.
So that is no more hearing. That means it is witness was there, statement has been recorded on 29th, again after arrest.
29th re maybe that 27th re se jo statement record katha kahuchi in the examination in chief, that is not, that may not be correct,
29.
but it was on 29th that the statement was
Because
recorded.
document has to prevail.
That is my point.
No, it is ultimately it's a document. Document shows that it document, as pointed out, document would prevail. Document shows what is the date of recording. Document shows that.
Don't we say already, always, men may lie, not the document. So it is the document which will prevail.
Document टा कहुची 12:30 बेले ए से बयान देला record हला. Ebong signature of the IO is also there, and he has put his date on that statement as 29/9/2000. तापर sequence देखो तो 12:30 रे statement record हला, then immediately गोटे बेलू खोला खोली आरंभ हला, dead body टा ता भितरु बाहरला, तापरे बाहर को आसिला परे 2टा रु 4टा भितरे inquest हेजी, कारण सब उल्टी फाल्टी देखिकिन तापरे inquest report टा prepare हेजी. So 2 घंटा लागिची तांकु सेटा, तापरे dead body जाइची postmortem report. तेणु एई जो in what way you say that how the PW5's evidence is discrepant to this documentary evidence.
One thing is that if it is recorded on 27
27 नहीं परा 29 आयो जोटा कहिछि सेटा it's a wrong statement.
Then if not, then in IO knowledge it came on 27/4/2004 lordship. Then at that moment where he didn't arrest.
No. That is why he has explained why he did not do it. He made arrangement. He issued requisition.
He had that information. He had that information. He had guarded the land, but he has not recorded the statement on that day, and that was not also recovered on that day.
Yes.
Information thila taku dead body 80 pointed out
on that day without the statement being recorded, then it would have been different.
एठी आपणकर इनफॉरमेशन रहिछि, स्पॉट मध्य से देखै दिछि, स्पॉट को गार्ड हेछि एवं रिक्विजिशन जो हेछि से माने जेहेतु डेरी हेछि गोटे दिन लागिछि एग्जीक्यूटिव मजिस्ट्रेट और डॉक्टर को, सेथि पई ना तो 27 रे किछि स्टेप नि आइ परला, ना 28 रे 29 तारिख दिन से जागा खोला हेकिनी अन्य माने को प्रेजेंस रे डेड बॉडी मिलला.
The time also specified by the doctor for conducting the PM is 2:30. So it is going consistent.
दीटा तीनटा माने इरोनियसली स्टेटमेंट से दे देछि जे से जो recorded the statement
Contrary to the
of
documents.
accused भाई हाँ सेटा आ गोटे जो कहछि जे 20-22 दिन पूर्वरु मिसिंग रिपोर्ट हला सेटा भी ठीक नुहे, कारण हेडा आसीछि 24 तारिख दिन. Have you find out any decision? Suppose let us say we accept this type of evidence. जे ଆପଣଙ୍କର at your instance the dead body was found from a buried condition. At your instance the weapon of offense was found. At your instance the other things has been pointed out that was found. Let us say that there is some kind of ए जो extrajudicial confession टा जदि भी there is ये हो ताहले काहे कि आमे accept करिवा नाही बा काहे कि conviction sustain हबनी. Mr. Mishra, another thing just you mark from the FIR.
Gotcha.
That is why I say that you once you repeatedly reading something, you can find out. आकु इनफॉरमेशन केबे मिलिला मध्य से विषय रे एफआईआर रे कहाई पेज 31 को आसंतु
My lords.
PW2 ताकु केबे इंटिमेशन देला से विषय रे मध्य क्लियरली कहाई आजी अर्थात 27/9/2004 तारिख सकाळे मु आम ग्राम पाखर करुणातल ग्रामर सुदाम भोईस PW2 ठारू जानिबा को पाइली जे आम ग्रामर स्वानसो और बापा को मारिदी so the moment he got the information he
Yes, Lord.
immediately
My lords.
तेणु एई जो भर्सन आसुची ना PW2 रो जे 4-5 दिन परे सी जानिला जानिकिनी ताकू जणैला काहाकू ये कोनी मु 5-6 दिन परे जानली ताकू जणैली 5-6 दिन it is not believable because the witness your witness another witness stated that on the date of lodging itself he has received the information from PW2 so prior to that it is your initial case that prior to that there was no intimation with PW1 that anybody has killed his father, much too by this appellant, and that too in connection with this witchcraft.
That is clear.
Clear.
Lordship.
27 तारिख पूर्वरु नथिला.
Not really.
Lordship, 27 तारिख पूर्वरु जदि नथिला, then there is no missing report also.
Not
No.
24. 24.
Missing report 24.
Only 24.
Missing report बापा
Not
को
20 to 22 days prior to that.
27 तारिख रे इनफॉरमेशन पाइला तक बापा को जो मारीची मारिवा घटनाटा ये मारिची बोली सी आसी कहला PW मिसिंग थिला से खोजुतिले चारियाडे
तीन
मिसिंग
दिन
रिपोर्ट
पूर्व जो 24 तारिख
हाँ,
दिन देइचंती
24 तारिख
21 दिन खोजिला परे
हाँ।
24 तारिख दिन देले 27 तारिख दिन he got the definite information
हाँ,
through this
हाँ।
PW2.
Lordship, yeah, it is believable. My father was absent and I was waiting for 21 days.
It happens. I mean, that is
And
not the
second
question.
thing is that, Lordship, extrajudicial
Yes.
confession should be made before a person whom I know that he will not reveal that to anybody.
Yes.
से प्रताप
Yes.
कहिछि सेइत पई से कहला
काहाकू न
जे
कहले भी
काहाकू न
कहछि।
कहबा
Yes.
पई
But he is the relative of that person.
no
तारा मामू से, तारा
deceased
जेठबापा.
अरे deceased is related to my grandfather
Yes.
and accused से ମଧ୍ୟ दी जनकर रिलेटिव
Yes, Lordship.
राइट ही को इनफॉर्मेंट वाज माय अंकल हैला तेणु से कहूनी फास्ट लाइन टे भी सेया कहूची से रेकॉर्डिंग ठीक हेनी डिसीज्ड इज रिलेटेड टू मी as grandfather and the accused तमाने दी जन जाक तार रिलेटिव तो ताकू ए विषय रे ताकू कहिला एवं से जाइकिनी डिस्क्लोज कला
Jadi Lordship,
So how do you
Four
say that?
also, Lordship proceed.
these are the
Para
relatives
four.
themselves, then how could I really reveal that, Lordship? ମୁଁ ଜାଣିବି ନା ତାକୁ ମାରିଛି ମାନେ ସେ obviously ତାକୁ କହିବ. Then ମୁଁ କେମିତି reveal କରିବି ତା ଆଗରେ? It is
No, that means the extrajudicial confession has to be before a third party always.
no, Lordship.
Then?
I am not. That means, Lordship, that person is related to the deceased and also to the accused.
Yes.
Then it is knowledge within that person that if I reveal that before anybody, who
He
is
will reveal
related-
it to others.
how can
How
how
can
he
they-
will know
he-
that he will reveal he has stated आमे बहु जिंस कहू ए मु तते कहली का कहबुनी कि से लोकटा मु छिना ताकू कहिदेली से का कहबो कि न पाइबो कोन मु am I sure
Otherwise, how this extrajudicial
हम बहु जिंस कोन
confession
मु ता
comes?
विषय या सुनछि कि मु या जानिछि ए तते कहिदेली किंतु का कहबुनी से लोक कोन चुपचाप रहि जाए याई बहुत लोक
Otherwise, how this will come? And if he would not have disclosed it, then how the things would have come?
केस तो ही न था
then Lordship, that extrajudicial confession should be corroborated by other
And that's
prosecution.
that's a different matter that's
Yes,
why
that
that-
part is. That will have to see whether it is it really required to be corroborated or not. How far it is there. That part will have to see.
you are right proposition is that extrajudicial confession is a very weak piece of evidence conviction should unless it inspire confidence there should be so those things are there but ये जो version आछि and of course there is some discrepancy between this PW2 and PW1 as to when that actually disclosure made कारण सी जो कହୁଛି ना 5 दिन परे एता डिस्क्लोजर होला that cannot be accepted
Cannot be believed. Yes.
ओके एवं 5 दिन परे हला घटनार मिस करिवार एवं मु ତା ପରଦିନ ଯାଇ ଜଣେଇଥିଲି ଏଇଟା
ସେଟା
ଆଟଲିଷ୍ଟ
ନାହିଁ।
ଏଇଟା ବିଶ୍ୱାସ କରିହବନି କାରଣ ଏଫଆଇଆର ରେ ହଉଛି ଯେ 27 ତାରିଖ ଦିନ ଆସି ଇନଫରମେସନ ହେଲା ତ ଏବଂ 24 ତାରିଖ ଦିନ ମିସିଂ ରିପୋର୍ଟ ତ ସେ ପର୍ଯ୍ୟନ୍ତ ତାର ନଲେଜ ହିଁ ନଥିଲା କାହାର ନଲେଜ ହିଁ ନଥିଲା ସୋ obviously PW2 ର ନଲେଜ ନଥିଲା ସେ ପର୍ଯ୍ୟନ୍ତ PW2 ଜାଣିବା ପରେ ଯାହା କହିଛି
That Lordship PW2 is not revealed that before the police also.
In 161.
No, Lordship, that is the statement of the PW9 IO that I had examined.
No,
Subramanian.
not exactly in verbatim. Substance is there, but not in verbatim that se mate kohila mu taku eita exactly the sentence that he has deposed in evidence.
Yes,
Exactly it doesn't found, but substantially it is there.
ପଢିଲୁ ଆପଣ 161 ଟାରେ
ମୁଁ କଣ ହଉଛି ବୋଲି ପଚାରିବାରେ ସେ କହିଲେ ଯେ ତାଙ୍କ ଗାଁର ଦାଦି ମାନେ
ନା ହଉଛି ସୁଦାମ ବହି ପରା
see it can't be in
ହଁ
precision. Then what is the difference in 161 and the evidence? You cannot expect that the evidence will be absolutely in verbatim in 161. It has to be. That gives the naturality. Had it been a parrot like 161 and evidence, there a doubt arises. So it's quite natural that some omissions are there. But those are not whether those omissions are
material or
material
not.
or not.
That is it.
But if Lordship 161 statement is not the substantial piece.
Exactly. That is why we don't take it. But for the purpose of 145, you are saying no. There is
Yes,
a
Lordship.
contradiction you are saying. So is it all contradiction or some kind of I mean,
এই কথা কইবার জন্য
see here he has stated so. Like in a mob, 100 people are there. So the witness has stated in 161, 100 people were there. In the evidence, he is saying that 75% were there. So it is not that the fact is not there. The statement is not there. Number is different. Number is discrepant. That cannot be taken as contradiction.
And another aspect, Lordship, is that 21 days, 21 दिन ହେଲା ସେମାନେ ଖୋଜୁଥିଲେ.
Right.
And that PW1 is one of the relative of that person. And he narrated that after 5 to 6 days of that occurrence, he went to the
That we have
house of.
already clarified that
Yes,
is
yes,
not a
Lordship.
proper one.
And Lordship 5-6 दिन ପରେ ଯଦି ସେ ଜାଣିଲା
ନାଇଁ
that
ସେଟା ଆମେ
it was-
ମନା କରୁଛି ପରା. That statement is not correct.
5-6 ଦିନ ପରେ ତା ପାଖରେ ଏଇ
ଯଦି-
ନଲେଜ ଥିଲା ଏଇଟା ବିଶ୍ୱାସ ଯୋଗ୍ୟ ନୁହେଁ
ନୁହେଁ।
ବିକଜ ହଁ
ଯଦି ଥିଲା ସେ ଫେର ଖୋଜିଲା କାହିଁକି
ହୁଁ
ଆଉ 27 ରେ କାହିଁ ଦେଲା so this statement is not
Have you brought out any decision?
Yes, Lordship.
What are those decisions?
One, Lordship, that is State of Punjab versus Keval Krishnan.
State of Punjab versus
Keval Krishnan. That is AIR 2020.
just a minute, just recent decision. State of Punjab versus Keval Krishnan. Which paragraph you want to place?
That is, in this case, that is convicted. Trial court has convicted that accused, but that is that one is reversed by the High Court, and Supreme Court also confirmed the judgment of the High Court, Lordship.
Okay,
Acquitted.
acquittal order was confirmed.
Yes, Lordship.
Yes. On
That
which
is-
point you want to place this decision?
That is
27 or
106.
24 or 106 को point रे आपण ए decision टा place करियो
that
चाहते
is Lordship, that is 106.
106.
हाँ को paragraph टा आपण दी लेज सेटा
Lordship, that is from 18. Extrajudicial confession is that is on 20 paragraph. And
Ah. Para 20 onwards.
20 onward.
That is 18 onwards.
18.
You want to place from 18 onward.
Yes, sir.
Okay, please.
In the instance case, we notice from the record that the dead body of the deceased lying in a naked condition in his house was first discovered by PW6, nephew of the deceased, on 12/12/1998 at around 1 p.m. Upon discovery of the dead body on the information provided by the PW6, FIR was registered against unknown accused and inquest etc. was carried out. What is important is that the name of the accused did not surface on the record till 25/1998. That is when he was alleged handed over to the police by PW3 upon a confession made by him before PW3. PW2, the sole witness of the last scene circumstance, in his deposition in court, stated that he had expressed his suspicion in respect of the accused involvement to police on 13/12/1998. The High Court opined that if PW2 was aware of the last scene circumstance and had made such a disclosure, there was no reason for the police not to act against the accused till 25/12/1998. Therefore, the statement of PW2 in respect of imparting knowledge of the last scene circumstance appeared doubtful, and it appeared that the witness was said
एटी
to
जोटा
claim-
हमें कहूथिलु जे if he had knowledge within 6 days,
Yes, sir.
if as per the PW, why then he did not go to the police
Yes.
station? Why he was searching for that?
Yes, Lordship.
Okay,
Yes.
so that is why এই ଯୋଉଟା 5-6 ଦିନ ପରେ PW2 ଜାଣିବାକୁ ପାଇଲା, it is not acceptable.
Yes.
Right? Yes.
Then, Lordship, the High Court also noticed that the alleged date and time when the deceased was last seen alive was at quite a distance from the date of time when the deceased was found dead. Indisputably, the deceased was found dead in his own house where the accused did not reside. The deceased was allegedly last seen alive in the company of the accused in the evening at around 7 p.m. of 10/12/1998, whereas the body of the deceased was found 2 days later on 12/12/98. Autopsy report based on autopsy conducted at around 4:15 p.m. on 12/12/98 noted occurrence of right mortis
No,
in
rigor mortis.
in the lower limbs, which gives rise to a possibility of death being within 30 hours of the autopsy, meaning thereby that death might have occurred much after 7 p.m. of 10/12/1998. In such circumstances, bearing in mind that the deceased was found dead in his house where the accused did not reside, and there was no evidence as to when the accused left the house, and that no one else could have entered the house in the interregnum, other intervening circumstances, including hand of some third person in the crime, was not ruled out. by the prosecution evidence.
Hmm.
From the reasons above, we are of the considered view that the High Court was justified in doubting the testimony of PW2 and finding the last scene occurrence inconclusive in pointing towards the guilt of the accused by excluding other hypotheses consistent with his innocence. Then Lordship 19, as regards to recovery of the khanjar is concerned, the same was denied by the accused and there was no serologist report to connect it with the crime. Therefore, it had very little incriminating value to sustain conviction on its own basis. Moreover, the High Court, on strength of the circumstances appearing in the evidence, doubted the date of arrest and upon consideration of the circumstances, accepted the possibility of the arrest of the accused being much earlier in point of time as claimed by the accused than what was set up by the prosecution. In such circumstances, the recovery, which was made on 25/12/1998, allegedly on disclosure made by the accused on 25/12/1998, becomes doubtful. The view of the High Court in this regard cannot be termed perverse as to warrant interference by this court. Then, Lordship, insofar as the evidence of extrajudicial confession made by the accused is concerned, the same was provided by PW3, a member of the Panchayat wherein the deceased resided. Ordinarily, a person makes a confession either to absolve oneself of the burden of guilt or to seek protection under the hope that the person to whom confession is made would protect him. Normally, a confession to absolve oneself of the guilt is made to a person on whom the confessor reposes confidence. The High Court noticed that the High Court noticed that there was no evidence to demonstrate that the accused had any prior relations with PW3 or that the accused hoped for or sought any help from PW3 and therefore made the confession to him. Notably, the accused denied making any such confession. For the reasons above, including other, which need not be put on record, the High Court discarded the circumstance of the accused making a confession before PW3 on 25/1998. Otherwise, also an extrajudicial confession is a very weak type of evidence, and solely on its basis, a conviction is not ordinarily to be recorded. Then the argument of the learned counsel for the appellant that since there was no proven enmity between the accused and the witnesses, therefore there was no reason to disbelieve them would not be of much help to the appellant because this is a case based on circumstantial evidence. In a case based on circumstantial evidence, not only do each of the incriminating
Leave it. The rest of the things, leave it. Para 22.
The argument that the accused has failed to discharge his burden under Section 106 of the Evidence Act and therefore his conviction was justified is misconceived. Section 106 of the Evidence Act does not absolve the prosecution of discharging its primary burden of proving the prosecution case beyond reasonable doubt. It is only when the prosecution has laid evidence which, if believed, will sustain a conviction or such makes out a prima facie case. The question arises of considering facts of which the burden of proof would lie upon the accused, Shivaji Chinnappa Patil versus State of Maharashtra. Here, as we have discussed above, firstly, the incriminating circumstances were not proved beyond the reasonable doubt, and secondly, they do not form a chain so complete from which it would be inferred with a degree of certainty that it is the accused and no one else who, within all human probability, committed the crime. In these circumstances, there was no occasion to place burden on the accused with the aid of Section 106 of the Evidence Act to prove his innocence or to disclose that he parted company of the deceased before his murder. For all these reasons above, while keeping in mind the view taken by the High Court is plausible view and that it was not pointed out that any material evidence was ignored or misread, we do not find a good reason to interfere with the order of acquittal passed by the High Court. That bill is according.
Mr. Mishra, ये जो weapon गुड़ाक recovery हला at the instance of so and so, so what happened to that? माने C report तो आसिलानी अपन करो. So in what way that is relevant?
I think that spade was being carried by the deceased.
Yes, Lord.
That spade was being
नहीं,
carried by
spade-
the deceased.
spade ଟା recovery ହେଇଛି ନା?
Recovery ହେଇଛି,
हाँ.
but no clue because
Yes.
हाँ.
କିଛି ସେଥିରେ ଇଏ ନଥିଲା.
The deceased was recovered, so and so, so and so.
That weapon was also not produced before the doctor.
ନା,
That
ସେଟା
which one, that body?
body
yes.
ବାଡିଟା ହଉଛି ଆପଣଙ୍କର
ବାଡିରେ ଗୋଟେ ମାରିଲା ପରେ ସେ ପଡିଗଲା ପରେ ଇଏ ତା ବେକରେ ଚଢିଛି.
ବେକରେ ଚଢି ଯାଇଛି ବୋଧେ ତାର ଯାହା ମାନେ ଏଥିରୁ
ଆଜ୍ଞା.
ଆସୁଛି କିନ୍ତୁ ୱେପନ ଟା ରିକଭରି ହେଲା ତ ୱେପନ ଟାକୁ ନା ତ ଡକ୍ଟର କୁ ଦେଖେଇଲେ ନା କିଛି ରିପୋର୍ଟ ପ୍ରୋଡ୍ୟୁସ କଲେ ଆପଣଙ୍କର ଯୋଉ ପାଞ୍ଚ ଛଅଟା ମୋଟିଭ ଏଇ ଯୋଉ ଆଣିଛି ମାନେ ସର୍କମଷ୍ଟାନ୍ସ ଯୋଉ ଆପଣଙ୍କର ପାରାଗ୍ରାଫ 9 ଯୋଉଟାକୁ ସେ ପ୍ରଥମରେ ପଢିଲେ ସେଠିକି ଯଦି ଆଣିବା ଏ ପ୍ରଥମ ପାର୍ଟ ଟା ଯୋଉ ମୋଟିଭ part neither it is there in the FIR nor PW1 has also stated that anything in that respect has been disclosed by PW2 आउथरे देखुनांती.
Yes, PW1 is not stated.
Right, so ना ताकू PW1 से मोटिव विषय कहिछि ना FIR विषय होइछि एवं बाकी have you brought out any find out any decision जदि एई circumstance गोटे डेड बॉडी टा ए टाइप रो पोजीशन में थिबो ए जो बॉडीड हेई थिबो बहुत केस अछि नदी बाली रे नै अक्यूज ताको पोती थाए लैंड रे पोती थाए बा कोठी सेई टाइप रो ये रे how it has been dealt with by the under section 27 it is accepted that 27 is admissible and এটা accept करा जिवो ताहाले कोन हबो. You search out in the Manupatra, you can get. Have you got Manipatra?
Yes,
If you will find accused giving recovery skeleton 27 dog. एती खाली मारदेले पड़े आसो एठी आसिलो एगुडा तो चेष्टा करिया कथा ना एठी कोन no you come here. Look, dead body buried accused recovery 27 recovery 27 evidence Pratimara. Right. खोजिले अपन पाइबे ना 76 decisions are there of the Honorable Supreme Court. See, one of the decisions we are just pointing out. The trunk of the body of the deceased so and so recovered on being pointed out by the two deceased. So how it has been dealt with. there. Paragraph 11. So far, accused Swansea is concerned for having last seen in the company of below. Corporate Swansea contacted Swansea. The dead body was caught in Swansea in two different places. There. Always Swansea. It is true that the accused did not make any statement admissible under section. This story has been heard in consequence of the information, and it been so to the burial of the dead body would have been attributed to the accused, depending upon arts in the registered. Still, the recovery of the dead body and pointing out the accused on the circumstances aforesaid lead to the inference that the accused had knowledge of the place where the dead body was caught into pieces while lying in sand. These three circumstances taken together, so and so, 201 by 30. Acute analysis is instead of the so and so, take you accuse the year last October 201. Following criminal appeal, Swansea's conviction under section so and so is set aside, is acquitted, he shall be so and so. Tajuddin is concerned with what is Tajuddin, unknown, EU line to observation of the law. His conviction at a Taharos on letter, still recovery of the Tajin pointing out by the is true that accused Tajuddin conviction of right. It is true that accused Tajuddin did not make any statement admissible under section 27 of the claim. No. The recovery of the dead body has been in consequence of the information recovered from Swansea. Had it been so, probably the authorship of the burial of the dead body could have been attributed to the accused depending on the past which accused made mistake. Still, recovery of the dead body and pointing out the circumstances oppositely to the inference that the accused had knowledge of the place where the dead body was caught into places lying buried. These three circumstances taken together, namely, the deceased was last seen in the company of the accused giving false explanation about the error, and the accused having knowledge entirely. But at the same time, it cannot be said that the accused has caused the evidential information. How would be conducted again under 201 here? If they say but at the same time, it cannot be said that the accused Tajuddin has caused any evidence of commission of that offense to disappear. His one so cannot be sustained. Again, point after 201 completely. Again, the line of 201 of set aside. 30. The last scene, data. So, they have relaxed. Even though that they did not, still they have taken out of the knowledge of place of. You search for this decision. There are a number of decisions. We are giving you time till because it's a question of somebody's life. You search out the decisions. We searched out Manu Patra in this way: dead body buried, accused recovery, 27 evidence. Etiki marlu, kojilu. At least Supreme Court or Chowstar decision, and of course our High Court. All these things are there. So. Jahardas case, in which this is from Mayurbhanj, their death sentence was imposed by the trial court. It was confirmed by this court. It was set aside by the Honorable Supreme Court. So it's a case of rape and murder.
The same is Dayanidhi Visoi also.
Hmm?
Dayanidhi Visoi was also
Huh.
confirmed by Supreme Court. Death sentence.
ତ ସେଠି ଏଇ ରିକଭରି ହେଇଥିଲା ତାର ଇନଷ୍ଟାନ୍ସ ରେ ରିକଭରି ହେଇଥିଲା ଯୋଉଟା କି ଆକ୍ସେପ୍ଟ କରିଥିଲେ ଟ୍ରାଏଲ କୋର୍ଟ ଆଉ ଏଠି ବଟ୍ ସୁପ୍ରିମ କୋର୍ଟ ରେ ସେଇ ଜିନିଷଟାକୁ ଡିସବିଲିଭ କଲେ ଯେ ଯଦି ଏଇଟା ଆକ୍ୟୁଜ୍ଡ ଇନଷ୍ଟାନ୍ସ ରେ ରିକଭରି ହେଲା ତାହେଲେ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ରେ ଆଟଲିଷ୍ଟ ଦେयर would have been some hint that ୟାର ସୂଚନା ଅନୁଯାୟୀ ଏଇ ଜାଗାରୁ ଇଏ କଲା ପରେ ଏଟା ମିଳିଲା there was nothing in that inquest report that at the instance of the accused the dead body was recovered. So say jo 27 thila ta dhare gote main part apart from last scene, so that was discarded and the accused was acquitted. So you go through these decisions, okay? So see that if anything can be. So we are taking it on Monday. Get ready, huh? So that's all.
Weekly list will. I may be permitted to withdraw a bail application without referring to the bank, matter may be.
Is it in their listing? Yes, understood.
Milord, one modification about that is on 193 weekly list. Praying for taken up today, Milord.
193.
Item 193.
30 also file for extension of
Please wait. What modification you are seeking for?
Milord, Lordship imposed the cost security and we also supplied cash security.
Cash security is there, 5 lakhs cash security.
And also supplied the Bellor document, Milord, that is gone for the verification also, Milord.
Yes.
File is required, Milord, all thing is there. Lordship is directed to state the verification of the document of the Bellor, Milord. Securities.
No, it's a disposed of matter.
Milord.
So what further you want?
Milord, Lordship imposed 5 lakh cash security, Milord. And so many accused person has gone, Milord. And that is the order of 2020, Milord. Till today, he has not arranged the money, Milord. And Lordship also directed to the lower court, is he got it gone in bail or not, Milord?
But report has come. Clerk? Item number 193, pra. You have not availed the bail order. That is the report. Now what do you want? You are an outsider or what?
Yes, Milord. I also given the document of the Bellor, Milord.
So
local
you have
security.
verified it.
I have to check the file.
Get that file.
Obliged.
Already.
Item 112.
Please one by one, yes.
168 of the main list. This matter was stripped over accidentally released from the original list. On the last occasion, you have not taken it, but only due to the absence of the vigilance advocate, it could not be taken up. So I pray that it will taken up today. 168. Item 168.
This is an anticipatory bail application.
And the co-acquitted already released on bail.
So you tell Mr. Rizvi to remain present he is supposed to be the counsel for the vigilance department in this particular bail application. His name is there. Ask one of the learned counsel for the vigilance department to remain present. It can be taken up. Yes.
Item 112, madam.
Mhm.
Is a 399,402.
Hmm.
And all accused are religion bail. Since Pradhan Jani, as per the decision of Pradhan Jani, this matter come before Lordship before vacation.
Yes.
And co-accused Symphony, I have no criminal antecedent, all are religion bail. I have by your Lordship.
No, it is coming for the first time.
My lord, or as per Pradhan Jani decision, madam.
No, it's all right, but you have got the case diary.
My lord, I have no criminal.
Why are you not giving the numbers if you are mentioning and want to be taken up so that they can? What is the offense here?
But 399,402.
So how many years you are in custody?
My lord, 6 months.
What is the date of custody?
My lord, custody is my lord. 7/9/2023. Sorry. 7/9/2023.
23?
Man.
Then how 6 months?
9 months, 3 months, 2 months. Was charge sheet submitted. My name is not FIR. And no criminal antecedent.
You are not present at the spot.
I have fled away from the spot.
So co-accused statement basis re apanku ye karagala. Then how many criminal antecedents you have?
No criminal antecedent.
The rejection order indicates that CD reveals that the petitioner along with other co-accused persons are involved in a series of cases
No, I have
of
no
similar in nature. That they have to verify.
direct to the court below to verify. If
The learned counsel, you get the case diary. This that is item number
112.
112. Learned counsel for the state seeks some time to produce the case diary as well as to obtain instruction about the criminal antecedent, if any, against the petitioner. It is submitted by the learned counsel for the petitioner that some of the co-accused persons have been released on bail. Can supply the copies of the bail order to the learned counsel for the state for verification. This matter in the week commencing from 20th of November 2023.
Pardon to mention, Lordship.
Please.
May it was in the supplementary list. 21st minute.
Assure.
Lordship, item number
185, my lord.
Kitne number it
Item 185.
Just a minute.
Lordship, item number 2.
Please wait. CDCA. Yes.
Lordship, item number 238. My senior is on BC to say a memo, pass a memo. So please kindly hear. He is on BC. Well, item number 238. My senior is appearing through VC for mentioning. So kindly hear him.
No. What is the matter?
It is a bail matter where the some of the accused are on bail, and it is passed on this court only.
Why mentioning? It is in 238.
238. It will not come because one
My lord,
accused.
Lordship, I am through. My lord, I am through virtual mode. Lordship, Lordship, on the last date of hearing, my lord has sought reply from the trial court. It is filed at the flag X. Lordship, I filed interim bail application 937/23. From last 3 years, he is in JC, and the health condition
Okay,
of
we'll
wife
see
is
when
not
the
good.
matter reaches. Yes, next.
The number will not come.
115 million. Custody million 19/6/2020. And million out of
115. It's coming for the first time.
Yes.
What do you want? Status reporting.
Custody date million
115. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since
19/6/2020.
19/6/2020.
Out of 15.
Item number 115. 19/6/20.
15টা 6টা
And out of 15 charge sheet witnesses, 6 witnesses have been examined.
Lordship.
Status report we called for.
Item 221 that I need take up for interim bail.
Hmm?
221 for interim bail.
No, they have to obtain instruction on that.
সেটা আসছে instruction status report আসছে
Okay, you call for that file.
221.
Yes.
283 permitted to withdraw.
Hmm?
283
pardon me?
permitted to withdraw.
Bring that memo.
Lordship, item number
Please
279.
wait. 283. That is ABLAPL number 949 of 2022.
My lord.
Learned counsel for the petitioner files withdraw. Yes.
Lordship, item number 279, BLAPL number 12257 of 23, permitted to withdraw, Your Lordship. The
Are you
petitioner,
filing memo?
yes,
Yes.
petitioner has been released by the court below.
All right. Item number 279. BLAPL number 12257 of 2023. Bashant Kumar Sarangi, Learned counsel for the petitioner, filed memo for withdrawal of the case, disposed of as withdrawn.
Item item 230. My lord, your lordship granted an interim bail for period of 3 months. I have filed one IA since September 30th, 2023 for passing of
Item number?
1288.
Item
number
This is a disposed of case, yes.
Yes, my lord. I have filed the application for passing appropriate order in terms of the Ranjit Digal's case.
What Ranjit Digal?
That once in the regular bail, if your lordship has came to a conclusion due to the non-examination of the witnesses for last 4 years and 9 months.
I'll file the memo, the case there. IA number transfer in appropriate order.
Period is expiring today.
Surrender and then move. Not in fact to pass any order. Dispose of. That is
Item number 185.
230 IA number 1288
My
of
lord, kindly take
2020.
up so that
Yes, next.
185, my lord.
4 also.
120.
185.
230.
This is a anticipatory bail, my lord. My lord, since last 2 months, the matter could not be reached.
130.
185. $75 old person, my lord.
185.
My lord.
Yes, anticipatory bail application.
My lord.
What do you want?
My lord, kindly taken up, my lord.
What is the offense here?
Offense 42468. In a LA case, advocate has withdrawn the money. Though the name of the petitioner does not reflect same, for that reason the police is trying to arrest him. The petitioner is a retired government employee. And he is all along in the village. But in the year 2023, the police has prayed for NBW against the
No, it's a 2017 case.
My lord.
So you opted, charge sheet submitted?
Charge sheet has not submitted. And your lordship may kindly see the annexure 2. NBW has been issued against the present petitioner in view of the prayer made by the IO in the year 2023.
You obtain instruction whether process under section 82, 83 has been issued or not.
130.
Item number 185. ABLAPL number 11612 of 2023. Since the FIR is dated 21/11/2017, the Learned Counsel for the state shall obtain instruction as to whether processes under section 82 and 83 CRPC has been issued or not. Please, this matter will commencing from 20th of November 2023. Yes.
Interim order, I
674/22. Yes.
75 years old person.
674/22 with BLAPL number 10,523. Last Monday I have mentioned the supplementary list as well.
What has happened? Why are you mentioning today? You want to be listed? File the memo.
Yes, sir.
Yes.
Next week, Your Lordship, any day and supplementary.
Yes.
My lord, item number 64 of the weekly list, my lord. Accused persons from the some case have already been granted bail by your lordship. I pray, my lord, it may be taken off.
Wait till matter. Yes.
Item 236, my lord. Out of 19 accused persons, including the main accused, all have been granted bail, except the present petitioner. He is in custody for last 3 years, my lord.
See that. Yes, call the matter from the week.
My lord, item 33, my lord. More than near about 8 years in custody.
I'll see that.
Supplementary list item number 1.
299 withdrawn, my lord.
Yes, item number 1.
The case, my lord, your lordship was pleased to grant bail, my lord, to the petition in the case under section 420 IPC with a before charge sheet, my lord, with a direction that he will deposit the cash security, the entire cash security of 73 lakhs, my lord, in 3 installments. Thereafter, my lord, the petitioner, the entire amount which was deposited in the petitioner's bank, my lord, transaction, the entire transaction amount which was
No,
deposited.
then that was modified also.
Yes, my lord.
The first order was passed on 16/5/23.
Yes.
That you are to furnish 25% of the cash security and then
The entire
give
amount.
an undertaking that the balance amount you are to deposit in 3 equal monthly installments.
Yes.
Then you filed an interim application for modification of that order. Then that was modified, and instead of 3 equal monthly installments,
6.
that was made to 6.
My lord.
Now,
Your lordship,
the last day you made a submission that the petitioner has deposited 46 lakhs
Yes.
in toto by now, and due to financial difficulty, he is unable to deposit the balance amount and ready to furnish property security. No documentary proof has been submitted, so report was called for from the trial court. So where is that report?
Whether he has deposited the 46 lakhs or not, your lordship was pleased to confirm.
Presiding officer so the petitioner has deposited 45 lakhs 63,892. So what is the balance amount? What is the initial order, first order?
About 27 lakhs 38,000. 334.
No.
73 lakhs. 73 lakhs.
What is that order dated?
16/5.
16/5. So what is your submission, Mr. Tripathi?
Well, are your lordship desire?
Deposited around 46 lakhs.
Yes, ma'am.
Not a single pie in his account, no property also, nothing, my lord.
For the rest amount, he is ready to furnish property security.
Yes.
All right. Mr. Dharanidhar Naik, learned senior advocate appearing for the petitioner, Mr. Tripathi for the learned additional standing counsel. As per the order dated 3/1/2023, instruction was sought for from the London Trial Court, that is presiding officer designated court under the OPID Act, Cuttack, as to how much amount the petitioner has deposited as per the bail order dated 16/5/2023. Report has been furnished by the London Trial Court to the effect that the petitioner has deposited 45,63,892.25 After hearing the London counsel for the respective parties and taking into account the financial condition of the petitioner, the order dated 16/5/2023 is modified to the extent that for the balance amount which was to be deposited by the petitioner as per the bail order dated 16/5/2023, the petitioner shall furnish property security.
Property security, not to the tune of 27 lakhs. 10 lakhs was.
Cannot be on either side. So IA is disposed of. Yes, next.
Lordship may grant me some time duration, my lord, 1 month time at least.
Within 4 weeks, property security to be furnished with. Yes. And which two cases?
That is, one is 3861 of 2023.
Yeah.
Another item is, my lord, 4726 of 2023. This is a case, my lord.
Just a minute. What is the
He has been granted interim bail also. He has availed at surrender in time.
how
He is
many
inside the
times
custodian.
how many times you have been granted interim bail?
One. Once, my lord.
So we are now I am taking of this BLAPL
3861 of 2023.
3861 dollar.
My lord, my lord. The present petitioner.
So you were initially taken into custody on what date?
21/3/2020.
Okay. Now the charge sheet submitted on the section.
My lord, charge sheet submitted on the section 302.
You have got the case diary, Mr.
Yes, ma'am. Yes, ma'am.
Okay. What are the offenses under which charge sheet submitted?
147,
Yes, 100.
302, 147, 148,
147, 148, 302. Yes.
120B,
On 20B.
212,
Yes.
109, 307, 149 of IPC.
Okay. So what is the name of the deceased?
So 2 persons they have been succumbed, my lord. The deceased name is, my lord,
Yes.
Aditya and Bhagwan Swain.
Aditya what?
Aditya Rana Singh.
So there are eyewitnesses to the occurrence.
PW4, who has been examined before the learned court below. Also, I have filed that copy and to handed over that copy to the State Council.
Is the sole eyewitness or other eyewitnesses are there?
That is, and initially there is no eyewitness to the occurrence. The PW4 projected that she happens to be the eyewitness, and oral declaration has been recorded by PW4. Your Lordship may kindly see the two order passed by Your Lordship.
That is in respect of the co-accused person.
Kalia, Susanta Pradhan. Your Lordship, paragraph 2, page 2 of Your Lordship, that has been continued. Entire thing has been depicted in the order.
No, that person's name was not there in the FIR.
My lord. Similarly, the present petitioner also. I am placing the FIR which has been registered against Pappu Pradhan, Jharia Pradhan, Baladev Pradhan, and four others unknown.
So this man is
not named in the Kumar Pradhan.
Kumar Pradhan. So you have solved the copy of the bail order?
Yes.
Mr. Tripathi?
Yes, ma'am.
Have you examined this bail order passed in favor of B. Brahmara alias Brahmarbar Pradhan in BLAPL number 4605 of 23?
Yes, Miller.
So,
But PW4 Miller,
yes,
4, he has categorically stated this Kumara Pradhan is there.
No, that person even Brahmar is also was also there.
Yes,
that
yes.
he has stated, but the role attributed so far as
assault part is the 2%.
Cutting of the right legs
Yes.
is concerned, that is against one Balabhadra alias Papu Pradhan and Balia Pradhan.
Balabhadra Pradhan, yes.
ସେଥିପାଇଁ ଯଦିଓ ଆର ନା FIR ରେ ନଥିଲା but dying declaration ରେ ଆସିଲା, since main role is attributed against that Balabhadra alias Papu Pradhan and Balia Pradhan, ସେଥିପାଇଁ bail ଦିଆଯାଇଥିଲା.
But these persons are actively participating in the modern meeting.
No, is it not that Brahmara was not present there?
Yes, there.
So, how do you distinguish the case of this
Similar
Brahmara?
footing. Similar footing.
Yes, learned counsel for the informant. You are the.
No, my lord, I am from the one of the court.
You are for the informant. So, madam, is not it correct that the petitioner is similarly situated like that Brahmar Pradhan who has been granted bail, or any distinctive feature is there?
PW4 and PW8, they are against before whom the dying declaration was made.
Right.
Para 4, he has categorically stated.
Okay, let us come to paragraph 4.
PW4 para 4.
This stated this, and suddenly what he has stated, that is mentioned ei lokomane jothre petitioner ro na achi Brahmara Pradhan ro madhya na achi semane asile ta pakku. Then he says thereafter, the most important hochi page 3 re, thereafter accused persons Pappu Pradhan and Balabhadra alias Balia Pradhan caught the right legs of the injured persons and severed. So, ଅନ୍ୟମାନଙ୍କ ନାଁରେ allegation ଥିଲା omnibus in nature, ଦୁଇ ଜଣଙ୍କ ନାଁରେ specific overtax ଥିଲା, ସେଥିପାଇଁ ଏଇ ଯୋଉ ଲୋକଟାକୁ bail ଦିଆଯାଇଥିଲା Brahmarbar Pradhan, taking into account the period of detention, and particularly when his name was not there in the FIR. So, London State Council says that it is almost stands on the similar footing. What is your submission?
Only this much, my lord. I have to check it out, man.
No, upon PW4 re evidence ଅଛି ନା, PW4 ରେ evidence ଦେଖୁନାହାନ୍ତି paragraph 4 ରେ, paragraph 4 ରେ ତ ସମସ୍ତଙ୍କ ନାଁ କହୁଛି ନା ପ୍ରଥମରେ. Thereafter all these accused persons came, right? Then came to the next page. They were armed with sword and lathi. Then thereafter the accused persons, then he says that so and so caught this so and so. So overtax is specific. ଅନ୍ୟ ନାଁରେ allegation ରହୁଛି, but in a general manner. So hard the learned counsel for the petitioner, learned counsel for the state, as well as learned counsel for the informant. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 21/3/2020, and he has been charge sheeted under section so and so. He further submitted that the name of the petitioner doesn't find place in the first information report.
Yes, madam.
An assailant of the deceased persons, namely Aditya Kumar Ran Singh and Bhagwan Swain. However, the name of the petitioner came in the dying declaration stated to have been made by deceased Bhagwan Swain while he was being shifted to the hospital before PW4 and PW8.
PW8 para 15 proceedings.
And submitted that in the dying declaration, specific overt has been attributed against two co-accused persons, namely Balabhadra alias Pappu Pradhan, Pappu Pradhan and Balabhadra alias Badiya Pradhan, right? And one of the co-accused, namely Brahmara alias Brahmarbar Pradhan, has been released on bail by this court in BLAPL number 4605 of 2023 as per order dated 13/10/2023, and the petitioner is similarly situated, and therefore the bail application may be favorably considered. He files the copy of the bail order of Brahmarbar Pradhan, which is taken on record. Learned counsel for the state, after going through the statements of PW4 and PW8, so also the bail order of the Brahmar alias Brahmarbar Pradhan, fairly submitted that the petitioner is similarly situated. Learned counsel for the informant opposed the prayer for bail. Considering the submission made by the learned counsel for the respective parties, I would have a line like that the petitioner was released on interim bail for some period, and after availing the same, he surrendered at right time. Considering the submission made by the learned counsel for the respective party, nature of accusation against the petitioner, release of the co-accused on bail, and absence of the name of the petitioner in the FIR, and taking into account his period of detention in judicial custody, as well as his conduct in complying with the interim bail order of this court, I am inclined to release the petitioner on bail allowed.
Same in BLPL number 4726 of 2020.
This is bail application number
4726 of 2023.
Yana bhi nahi.
Nah, same.
See, and his period of detention?
Same period.
Okay, same. Next one is also same. BLAPL number 4726 of 2023. Yes.
may submit one slide pilot.
number 941.
PW8 para 15 re Brahmarpura na nahi. PW8
I have considered only the evidence of PW4 and they are
8 also was there.
okay. No, I have stated that. Yes, next.
My lord, BLAPL number 941 of 2023, my lord.
Yeah.
My lord, the petitioner also stand on similar footing. His
Ranjit Pradhan.
Again. And
Ranjit Pradhan, what is the date of custody?
My lord, 11 January 2021.
तार लिखी दियो ना फास्ट है BLAPL 941 11 January 2021
my lord,
and whether he was released on interim bail at any point of time.
No, my lord.
No, ताले interim bail टा काटी देवे आदि. So बाकी सब समान कर देवे, allow कर देवे.
My lord, another one 4941 man.
4941 बेटा कहीं? अच्छा 225. Okay, that name is
Tera alias Susant Behera.
Just a minute. 2 कहते? हाँ, Tera alias Sushant Behera. So
not named in FIR, my lord.
What is the date of custody?
Madam 17/3/2020.
एटर कर दिया 17/3/2020. Interim bail अच्छी.
Interim bail and surrender.
Interim bail. So same footing allowed.
And another
number
10250.
Just a minute. I suppose S list supplementary list. How
10250.
That is in the weekly supplementary list. Dipu Pradhan.
Dipu Pradhan, my lord.
Dipu Pradhan, what do you say?
My lord, not named in FIR and similar cutting.
He was on interim bail.
No, my lord.
And what is the date of custody?
27/2/2020.
27/2/2020 ହେଲା ବାକି ଆଉ ସବୁ ସମାନ ଲେଖିଦେବେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ରେ ନଥିଲା ନହେଲେ allowed.
Item number 3.
May I please, your lordship? Lord, the present petitioner filed a separate IA for interim bail. The petitioner's mother is suffering from heart problem, and the treating doctor suggested for surgery.
What is that IA you are now pressing for?
IA number 1476.
1476. This is for the interim bail on the ground of mother's
surgery.
So have you taken instruction?
Yesterday copy was served over me.
Take instruction. Is an outsider or from Odisha?
He is from Bhubaneswar.
Okay. So IA number 1476 of 23. This is an application for interim bail on the ground of mother's settlement. Some medical documents have been annexed to the interim application. Mr. Vivekanand Bhuya as well as Mr. J.P. Patral and special counsel appearing for the state of Orissa in OPID matter submitted that the copy of the IA was served yesterday and they are yet to obtain instruction on the interim application. Put up this matter. Next, Aniva Friday, list this matter on 17 November 2023. The instruction on the interim application be obtained in the meantime. The names of Mr. Bhuya and Mr. Patra be reflected in the cause list henceforth. Free copy of the order be handed over to them. Yes.
Item number 4.
Either 16 or any day.
ସେଗୁଡାକ ଆସୁଛି ଇଏ ପରା ମାନେ ଶୁକ୍ରବାରରେ ଆସୁଛି ଏ ମ୍ୟାଟର ଗୁଡା ଏଟା ସବୁ ହିୟରିଂ ଡେ ରହିଯାଉଛି
17ଟା ଟିକେ
ଅସୁବିଧା ଅଛି ଇଏ ମିଷ୍ଟର ପାତ୍ରଙ୍କୁ ପଠେଇଦେବେନି ଖାଲି ତ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବା କଥା ପଠେଇ ମୁଁ ନାଁ ଦି ଜଣଙ୍କର ଲେଖିଦେବି
Item number 4.
Please, your lordship. Lordship, this is an application for extension of interim order, Lordship. Lordship, in the instance case, 1 month interim bail was granted to the petitioner on the ground of knee surgery of the wife of the petitioner. Subsequently, because of high diabetes, her knee could not be operated. Subsequently, in Annexure B3 series, previously the petitioner was operated for shoulder injury and nails were implanted on his shoulder. Recently, because of pain, the doctor has suggested for operation. That's why pray for 3 months time.
Surrender. Let us show your conduct, then you move another application. I am not inclined to extend the interim bail order. Disposed of. Yes, next.
Okay.
Item number 5.
A petitioner is in custody, my lord, since 26/6/2023 for alleged offence, my lord, 399402, read with 25(1)(b) and A of the Arms Act.
Mr. Tripathi,
Yes.
on the last day you made a submission that you have not received the case diary. Now
The
you
case
have
diary is received.
So the offences are Mr. Sahoo.
399402, read with 25(1)(b) small A of the Arms Act.
And you are in custody since
26/6/2023.
You are found at the spot or subsequently?
No, subsequently I have been apprehended.
Arrested.
Accused statement.
You have got 2 criminal
antecedent.
What is your submission, Mr.
Yes, Mr. Artist.
Are the learned counsel for the petitioner, learned counsel for the state, considering the submission made by the learned counsel for the petitioner, that the petitioner is in judicial custody since 26/6/2023. He was not arrested from the spot, but on the basis of confessional statement of co-accused, he was arraigned as an accused, and charge sheet has been submitted under section 399-402 of the Indian Penal Code, section 25 bracket 1 hyphen capital B bracket ends outer bracket small a of the Arms Act. And after hearing the learned counsel for the state who submitted that the petitioner has got 2 criminal antecedents, and further going through the comprehensive affidavit filed by the learned counsel for the petitioner relating to the status of those cases, I am inclined to release the petitioner on bail allowed.
Oblige. Item number 6.
May I please, your lordship? I am appearing with Mr. Chaudhary in this case, your lordship.
Yeah.
Your lordship, on last occasion, your lordship had directed to take instruction as regards to deposit of 32 lakhs. Your lordship's order is
Yes.
My lord, in this connection, may I submit, your lordship, that charge all the accused persons, there are 12. This person is not named in the FIR, they are on bail. Now, first of such case, your lordship had allowed, that was Mamta Parida, against whom the allegation was that she has executed the sale deed, impersonating someone. That is 3986 of 2023, my lord. There your lordship was kind enough to release her on bail. Now, here in the charge sheet, my lord would find that the allegation against me at page 47, my lords. 18.18. May I pray your lordship may turn to page 47. 18.18. Bottom paragraph, your lordship. It is revealed that the identifier Krishna Chandra Behera, knowing very well that Gayatri Malik has impersonated a Satyabhama Das, identified her as Satyabhama Das. Krishna Chandra Behera had identified the impersonated lady as Gayatri Malik and facilitated the execution of fraudulent sale deed in favor of Pradipta Behera, Monalisa Behera, Sulochana Pradhan, Damayanti Das. It is further revealed that Krishna Chandra Behera along with Gayatri Malik has taken rupees 10,000 from the accused person such and such, named in the SR office at the time of execution sale deed. It is further revealed that the Krishna Chandra Behera has also given thumb impression and his photograph in the said for sale deed, besides using the Aadhaar card and voter ID card at the time of execution. The next page, your lordship, it is ascertained that the accused persons, namely such and such, have received 2 lakhs cash from Pradipta Behera, 9 lakhs 20,000 and 2 lakhs cash from Monalisa Behera. It is ascertained that the accused persons have failed to give possession of the said properties after sale, so also failed to return the sale consideration. So, my lord, total transaction as per this charge sheet is, my lord, about 11 lakhs. 11 lakhs.
Kemdi?
9 lakh ଆଉ 2 lakh 9 lakh 20 2 lakh
No.
ଅଲଗା ଟ୍ରାଞ୍ଜାକ୍ସନ ମାନେ ଅଛି
2 ଲକ୍ଷ ପ୍ରଦୀପ୍ତ ବେହେରାଠୁ ନେଲେ, 9 ଲକ୍ଷ 20,000 ସୁଲୋଚନା ପ୍ରଧାନଠୁ ନେଲେ, ଆଉ 2 ଲକ୍ଷ ନେଲେ ମୋନାଲିସା ପ୍ରଧାନ, ମୋନାଲିସା ବେହେରା।
11 ଲକ୍ଷ ହେଲା।
9 2 11 କଣ ମ କାଲକୁଲେଟର ବାହାର କଲେ 9 2 11 2 13 ହବ ନା
13 ଆଗ ଦୁଇଟା ମୁଁ ଛାଡିଦେବି।
ଆଚ୍ଛା 13 ଲକ୍ଷ 20,000 ଟଙ୍କା ହଉଛି। ଆପଣ କେମିତି କହିଲେ ସେଦିନ ହିସାବ କରି ମିଷ୍ଟର
ମତେ 10,000
ଲାଷ୍ଟ ଅକେଜନ ଆଇ ୱାଜ ଏପିଆରିଂ ସେଥିରେ ଅଲଗା ଟ୍ରାଞ୍ଜାକ୍ସନ ମାନେ ବି ହେଇଛି ବଟ ୟୋର ଲର୍ଡସିପ ଆଇ ହାଭ stated in that day also I will take the financial part and see of that accused man. I have received she is impersonated in 4 cases, your lordship.
So far as this case is concerned,
yes 18 lakhs, your lordship. I am giving this.
এই কেস রে ଆପଣଙ୍କର ଯୋଉ କନକ୍ଲୁଜନ ଆସିଲା, ଯୋଉ ପାରାଗ୍ରାଫ 9 ମିଷ୍ଟର ସରଙ୍ଗୀ ପ୍ଲେସ୍, ସେଥିରେ ତ 13 lakhs 20,000 ଟଙ୍କା ହଉଛି, 13 ଲକ୍ଷ 20।
I have asked them, they have sent in another one.
No, thereafter maybe because when this charge sheet was submitted, this investigation was kept open. That means maybe that afterwards it was found that so now what is the ei case re kete kohuna
18 lakh
18 lakh. So that statement was not correct. Yes, Mr. Sarangi, are you ready to deposit that amount? Now it is not 30 lakhs.
Then I will again once again bother your lordship. I have received only 10,000.
No, that money has been received
by somebody else.
Not only by this accused, my lord. By
Others are there.
everyone.
And my lord,
Others are.
everybody except this person, my lord, is behind bail, behind bar.
18 lakhs, yes. So what terms and conditions were imposed on them? On those accused persons who have been released on bail?
One person, 5 lakhs property security. That is released by, that is.
Can you show that whether in those cases also, who are the persons who have been released on bail? Au tanko pai cash security heithila na property security?
Nahi sir, gote rahichi property security. Only one.
Au sabu cash security?
Kichi security nahi sir. This is the first order passed by my lords.
ଆପଣ କେତେ ଜଣ ଯାଇଛନ୍ତି କହୁନାହାନ୍ତି?
11 ଜଣ ସାର୍ ଯାଇଛନ୍ତି।
କାଇଁ 11ଟା ବେଲ୍ ଅର୍ଡର କାଇଁ? ଯଦି ଜାଣିନାହାନ୍ତି ତାହେଲେ ମୁଁ ମଗେଇଦେବି, ଟୋଟାଲ ଡିଟେଲ ପଳେଇ ଆସିବ ସେଟା।
ଅଛି ସାର୍, ଅଛି
ଦିଅନ୍ତୁ ସବୁ।
ବଳଧର ଦାସ। ତାପରେ ଏଇଟା ଦେଲି ନା 398 ଆଉ ଦିଅନ୍ତୁ।
This is EOW Bhubaneswar PS case number 7 of 23. तारी संक्रांत रे
ସବୁ sir ସେଇଟା। Mamta Parida was the first person whom your lordship passed their order of 25-4.
ସବୁଗୁଡା 7 PS case number ସବୁଗୁଡା ଦେଖି।
ଆଉ ଗୋଟେ sir trial court ମଧ୍ୟ release
PS
କରିଛନ୍ତି
case number
identified କୁ।
PS case number check करो। अन्य गुड़ा फेरी दियो। अन्य केस रे दियंतुनी आपण कहली परा खाली 7 रो दियंतु।
एगुला सब 7 रो सर।
ओहो आपण 9टा देई जनी परा एठी फेरेला आपण को।
कोडा एटा 7टा फेरेन तो एटा आज ए केस रो और डबल दे दी।
This is 7 of 23, right? Then another is
सुबोध। नहीं डबल डबल। अर्जुन देली की? अर्जुन देली।
बलधर दीटा बेल ऑर्डर देइछन आपण। 2 बेल ऑर्डर्स यू ऑफ मु रिपोर्ट मगै दउछि लेखन।
मु सर दे दउछि लॉर्डशिप में पास।
ना देरी हो लेखन। लेट ए रिपोर्ट बी कॉल्ड
एगुला सर देली आउ 3टा अछि।
मु मगै दउछि पळाय सो लेट ए रिपोर्ट बी कॉल्ड फॉर फ्रॉम द learned SDGM Bhubaneswar in connection with city case number 270 of 2023 which arises out of EOW Bhubaneswar PS case number 7 dated 21/2/2023 as to how many accused persons have been released on bail in this case and about their names and whether any of them have been directed to furnish cash security or not. The report should reach this court on or before 15th of November 2023, matter to be listed on 17th November 2023. Eta new.
Confusion है so.
Malord, we have furnished a report also.
ये सीटा से जो ये the Learned Council for the ऊपर लिख देवे. State has furnished a report of sworn so to the that the so far total amount involved in this case is rupees 18 lakhs. Like I said, देखी लेते. फाइल होता. वकालतनामा. वकालतनामा has been filed, taken on record. Name may be reflected in the cause list. Yes.
Item number 7.
May I please, my lord? My lord, the petition is in custody since 7th February 2020, your lordship.
Just
this is the third journey of the petitioner.
OPID lagi.
Millard, in this case, he was acquitted from Section 6 of OPID. Now, therefore, the state council will only conduct the case.
No, he might have been acquitted, but suppose tomorrow you take a decision to challenge that acquittal order from
6
OPID.
OPID. Then we will have to challenge that part of the order by preparing an appeal.
Right. So once it is to be seen that which court has you have been assigned that you are to appear in those cases in which OPID court has disposed of the matter. OPID acts are there. So OPID Act court, that means presiding officer, they disposed of, and one of the charge was also under section 6 of the OPID Act. So merely because that charge has been, that doesn't mean that you will not appear. I don't think so.
No, I don't say that I
So,
will not appeal.
so now this is a appeal, phrase appeal, na?
My lord.
So
He is on bail, but that to be confirmed by my lord. That is after 3 years conviction, he has been released on bail by the London OPID court.
Alright.
So that has to be confirmed by him.
Had the London Council for the. There are some defect as
I have removed that. I have filed another IA, that is 2721 of 2023. In that, notary has stamped and signed and identified.
IA number 2530 you are not pressing.
Not pressing.
All right. I first like it on the IA number 2530 of 23. The London Council for the petitioner doesn't want to press this application. Hala. Tapare main bail application to main criminal appeal upare asuntu. The London Council for the appellant submit that he has removed all the defects as pointed out by the stamp reporters. Had the Land Council for the appellant, Mr. Vivekanand Bhuyan and Mr. J.P. Patra of Land Special Counsel for the State of Orissa in OPID Act matter, admit call for the trial court record. You are on bail during trial, so it was on bail, so bail allowed and stay realization of fine. Free copy of the order be handed over to Mr. Bhuyan.
God bless.
God bless.
Yes.
Item number 9.
Item number 9, Your Lordship.
You are present from the side of this.
Yeah, ma'am.
Okay.
On behalf of Mr. Sangram Das, ma'am.
ସଂଗ୍ରାମ ନାୟକ ଆଜି ଆସିଛନ୍ତି କୋର୍ଟକୁ?
No, my lord.
ମୁଁ ଲେଖିଦଉଛି ଆପଣଙ୍କ ନାଁ on behalf of Mr. Swan.
Ma'am.
So the Land and Council for the petitioner seeks for an adjournment. Mrs. Tripathi is present on behalf of Mr. Sangram Naik, the Land and Standing Council for the Vigilance Department. Case is adjourned. List this matter. Give a date. Any passover matter?
Quickly list item number 1.
My lord, item 1 on behalf of Mr. Sangram Das, I pray for adjournment next week.
Next week?
Ma'am.
Come
His wife
next
admitted
Friday.
in hospital.
It's all right.
Ma'am.
Mention is made on behalf of Mr. Sangram Das, Land and Standing Council for the Vigilance Department, to take up this matter next week. Is this matter on 17 November 2023.
Okay.
Item number 2.
Mr. Gopal Krishna Mahanti. So, pass over.
The rejection order of 2022 March.
कि नाहती तो काले आसिवे कौन? Yes.
Item number 3.
Monica Samal. User
May I please, my lord? My lord, on last order dated 1/9/23, your lordship has 6 for antecedents of the petitioner.
Land count submitted 72 years. Judicial custody out of 23 charge sheet witnesses, 5 witnesses. Antecedent मगा ହେଇଥିଲା कौन आसिला?
No antecedent.
No CA. So now only 5 witnesses have been examined.
Yes, my lord.
And what they have, is this the first application or earlier rejected?
Earlier rejected, this is the third time, my lord. I'm custody since 8/11/2020.
No, that I have noted down.
Yes, my
When your bail application was last rejected?
last rejected, my lord. দেখেন কি বলছে এটা?
7138 of 2021.
Yes, my lord. এটা তো
No, in that it was not rejected. You are granted interim bail for a period of 3 months.
yes, I've surrendered again, moved surrender in time, again moved.
So now, what is the stage now?
Stage is same, my lord. That
Okay,
only
5 witnesses. So same stage it is there, Mr. Hard, the learned counsel for the petitioner, learned counsel for the state. Considering the submission made by the learned counsel for the petitioner, that the petitioner is in judicial custody since 8/1/2020.
8/11, my lord.
Sorry, 8/11/2020. And out of 23 charge sheet witnesses, only 5 witnesses have been examined. And petitioner was earlier granted interim bail for a period of 3 months as per order dated 16/9/2022 in BLAPL number 7138 of 2021. And after availing the same, he surrendered at right time. And perusing the status report furnished by the Lenin trial court and hearing the Lenin counsel for the state in view of the delayed disposal of the trial and conduct of the petitioner in complying with the earlier interim bail order, I am inclined to release the petitioner on interim bail for 3 months disposed of.
Obliged.
Item number 6.
May I please, Your Honor? My lord, this is a case under section 376, subsection 3 of IPC and POSCO Act. And the petitioner has
no status. Yes, next.
Item number 8.
I'm at a VC and permitted to withdraw, my lord.
Mr. Mahapatra, Learned
Mahapatra,
Counsel appearing for the petitioner seeks permission to withdraw the bail application disposed of as withdrawn. Yes.
Item number 9.
Mr. Devasnan Das. Or there.
In this case, my lord, I am for the informal appearing.
He is not there, so I am passing it over. You have received the
Item 9.
yes.
Also password.
Password. Password to korichi mu. You have received the case diary?
Yes, sir.
Okay. Yes.
They have to produce a surrender certificate.
All right. He is asking for a password. Yes.
Item 10.
10, Mr. Yes.
In the second bail application, offense under section 20 BC of and 29 of NDPS section. Petitioner in custody since 13/9/2020.
13/9/20.
13/9/20.
Yeah.
Last bail rejected by this only honorable court. My trial to conclude 6 months. My BLP number 7143.
714 order ଅଛି ଆପଣ ପାଖରେ ଦିଅନ୍ତୁ so ବର୍ତ୍ତମାନ stage କଣ
My trial and commerce no witness exam.
status report ମଗାଇଥିଲା
No.
But a fresh matter Land Council for the petitioner submitted that the petitioner is in judicial custody since 13/9/2020 and earlier he approached this court for bail in BLAPL number 7143 of 2021 which was disposed of on 24/9/2022 and while rejecting the bail application, this court directed the London trial court to dispose of the case as expeditiously as possible, preferably within a period of 6 months. He submitted that till date
No witness exam.
Not a single witness has been examined. Let a status report be called for. Baki list this matter on such and such. ये order टाकू रखी था, है ना?
CDCL.
हाँ, CDCM हो गई.
Item 11.
My lord, the petitioner is in custody since 1/7/2020, my lord. Co-accused persons have been released on bail. That is Annex 3 series, my lord.
आगुर आस्थिल ना प्रथम bail
It is second, my lord. Second jana.
Just a minute. So your custody date is
1/7/2020.
So what is your first bail application?
That is, my lord, BLAPL number 5859.
And what order was passed there?
2020.
It was rejected. Now what is the position in the trial court?
Trial, my lord, as per the 2 witness has been examined, my lord.
नहीं ये केस रे FIR थिला unknown persons.
My lord, 10 to 12.
So you were identified in the TI parade.
Yes. My lord.
So how many persons identified you?
My lord, those persons have been identified, have been released on bail. That is unnecessary.
ମୁଁ କଣ ପଚାରୁଛି ଆପଣ କଣ କହୁଛନ୍ତି ଆପଣଙ୍କୁ କେତେ ଜଣ ଲୋକ ଆଇଡେଣ୍ଟିଫାଏ କରିଥିଲେ ଜାଣିନାହାନ୍ତି କେମିତି 395 ରେ କେମିତି ବେଲ୍ ମୁଭ୍ କରିବେ ଆପଣ
ଯୋଉମାନେ ଆଇଡେଣ୍ଟିଫାଏଡ ହେଇଛନ୍ତି ସେମାନେ ବେଲ୍ ରେ ଯାଇଛନ୍ତି unnecessary 3 series.
2 persons identified.
2 persons identified.
PW1 and 2.
PW1 and PW2. And they have also identified them in court. Right?
That is reflected also.
his submission is that some of the persons who were
Similar
identified.
putting achandi, my lord, this accused also. But thing is that the other accused does not have criminal antecedent.
Okay.
But so far, this present petition having criminal antecedent, and that is to be verified, ma'am. Yeah, because that is not there in the city.
So you have to ascertain this only CA.
Right.
All right. The learned counsel for the petitioner submitted that the petitioners are in judicial custody since 1/7/2022.
20 man.
Acha, 1/7/2020. And PW1 and PW2 not only identified the petitioner, but also some of the co-accused persons in TI period as well as during trial. And the persons identified have already been released on bail. And therefore, the petitioner's bail application may be favorably considered on the ground of parity and equity. The learned counsel for the state, while not disputing that as per the evidence of the two identifying witnesses, the petitioners are similarly situated like the co-accused persons who have been enlarged on bail, seeks for an adjournment on the ground to obtain the obtain instruction about the criminal antecedents, if any, against the petitioners. Please this matter on such and such date. Yes.
Item 12.
Please, Your Lordship. Your Lordship, the present petitioner is in custody since 30/11/2021.
Yes.
This is the second round of application of the present petitioner. The earlier bail application was bail appeal number 540 of 2022, Your Lordship. In the said application, Your Lordship, we had been directed that the Honorable Trial Court was directed to complete the trial within second quarter of 2023. Your Lordship, out of 14 charge sheeted witnesses, Your Lordship, we have instructions that only 4 have been examined. So, Your Lordship, may we please to call for a status report?
The learned counsel for the petitioner submitted that when the petitioner approached this court last time for bail in BLAPL number 540 of 2022, as per order dated 13/2/2023, taking into account the later of the Lennon trial court. No, taking into account the status report furnished by the Lennon trial court, that the case is expected to be disposed of by second quarter of 2023. This court directed the Lennon trial court to expedite the trial and conclude the same by second quarter of 2023. And the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the aforesaid period. Learned counsel further submits that she has received instruction that out of 14 charge sheet witnesses, only 4 witnesses have been examined so far in the trial court. In view of such submission, status report we called for. Place this matter on such and such date. Yes, next.
Much obliged.
City and CM.
Citizen.
Much obliged.
Item 13.
I'm at BC, my lord, or permitted to withdraw, my lord. Trial already concluded.
Mr. Mahapatra, learned counsel for the petitioner, seeks permission to withdraw on the ground that trial has already been concluded, disposed of as infructuous. Yes.
Item 14.
Let's say praying for adjournment on behalf of Balram Naik.
You have received the case diary?
Yes, sir.
And counsel for the state submits that he has received the case diaries. Counsel for the petitioner seeks for an adjournment. List this matter on such and such date. Yes, next.
Much obliged.
Item 15.
Item 15, I may be permitted through BC, my lords.
Yes, sir.
My lords, petitioner is in custody since 17/3/2021, my lords.
Just a minute. 17/3/21.
My
Yes.
lords. This is
Charge
his,
sheet.
my lords. This is second application, my lords.
Okay. First application is BLAPL
29/7/2022, my lords.
कहीं से order कहीं. This is item number 15. 15 ने तो आसिनी 15 ने गोटे order आसी 4009 और 6721.
And that was disposed, my lords, on the ground that trial has commenced. The order of disposal is 27/2022. More than 1 year ago, my lords. That was disposed of since trial had commenced there at that time, my lords.
Now,
So
what is the position now?
Position, my lords, out of 18 witnesses, my lords.
Yes.
As per my last instruction, my lord, 4 witnesses were examined, my lords.
So it's a 302 case. Have you supplied the deposition copies of the?
No, I have not. But I have filed that order sheet of the learned court below regarding the status, my lords. That has not come on record, my lords. I have filed the entire order sheet of the learned trial court regarding that paucity in the trial.
What is the last date of that certified copy of that order?
Yes, your lordship.
So,
yes. That last order, my lords, 2/5/2023. Up to that,
6 मास गलानी और तो केते साखी हेतिबे मु स्टेटस रिपोर्ट मगे दु.
Yes,
लेखन the learned counsel for the petitioner submitted that earlier the petitioner approached this court for bail in BLAPL number 2972 of 2022, which was disposed of on 26/7/2022. Custody likely. The petitioner is in judicial custody since 17/3/2021, and he has received instruction that by May 2023, out of 18 charge sheet witnesses, only 4 witnesses have been examined. Since the learned counsel for the petitioner has not received up-to-date instruction, let a status report be called for. And say jo charta sakhiro deposition apon par achi?
No, my lords, it is not with me, my lords.
The learned
as per their averment in court below, 10 witnesses already been examined. Rejection order shows. Their averment is there.
Fine.
Page 13, your lordship. It is further argued that though 10 number of witnesses have already been examined in this case.
Some witnesses have been examined. Let a status report be called for, and while submitting the status report, the learned trial court shall send the deposition copies of all the witnesses examined so far. And after receipt of the same, a set of deposition be supplied to the learned counsel for the state. Another set be supplied to the learned counsel for the petitioner. Put up this matter on such and such date. Yes.
Item 16.
Please, your lordship. Lordship, the petitioner is in custody, my lord, on 9/2/2021. Since
the status of the case may be called for, my lord, in this case.
Yes, Mr. Tripathi.
The status of the case.
Report.
Yes, my lord. There are 15 charge-sheeted witness.
15.
Yes, out of 10 has been examined in the month of January.
आपण कौन इंस्ट्रक्शन कौन जनवरी भितर 15 टार 10 टा हे जाइथिले या भितर 10 मास पळिलानी
आउ दुईटा हाइचंती आ तापरे आउ केस अदर अक्यूज मानक पई की वारंट हे जाइछि सो दैट
स्टेटस रिपोर्ट मगाइयो लर्निंग काउंसिल फॉर द state pointed out from the rejection order that by
Lord space granted bail do
just a minute status report आज rejection order लिखाई छी जोटा कहउछन मिस्टर त्रिपाठी
ସେମାନେ ଦେଇଛନ୍ତି
Acha. Learned counsel for the state submitted that he has received the deposition copy of 10 witnesses from the learned
ସରି ମୋର
counsel.
ପାଞ୍ଚଟା ଦେଇଛନ୍ତି।
Oh, has received the deposition copy of.
ପାଞ୍ଚଟା ନାହିଁ ସବସିକ୍ୱେଣ୍ଟଲି ଆଉ ଡିପୋଜିଟ୍ ସବୁ ଯାକ କରିଥିଲୁ କିନ୍ତୁ ଯଦି ଲାଗିନଥିବ ଆସିନଥିବ କିନ୍ତୁ 12ଟା ୱିଟନେସ୍ ଆମେ ଅଲରେଡି वी हैव फाइल्ड
Deposition copy of 5 witnesses.
Substantive.
So, learned counsel for the petitioner submitted that 12 witnesses have been examined so far in the trial court. You have not received the deposition copy of PW6 onwards?
No, Miller. Only
Let
5.
the deposition copies of PW6 onwards be supplied to the learned counsel for the state, and a status report be called for from the learned trial court. List this matter on such and such date. Yes.
Item 17.
May I please your lordship? The petitioner is in custody since 19/1/2020.
Yes.
Custody since 19 January 2020 and valid BLAPL number 4355. This annual court directed on 9/11/2022 to complete the trial within a period of 4 months. Thereafter also again on valid order dated 26th June 23, again 4 months was given. But out of 23 witnesses, last witness was examined on the 10th October of 2023. Witness number 8. And other co-accused persons has already been granted bail by your lordships also. And
No, you have never been granted interim bail.
Interim bail was granted for 3 months.
Kebe.
My lord, in BLAPL number 12822 of 2022 for a period of month.
9/11/2022.
My lord.
नहीं चादर तो कुछ ऑर्डर ही नथला.
My lord.
12822 of 2022 रे को ऑर्डर रे अपन 3 मास बेल दिया इतला.
3 मास 1 month my lord.
अच्छा 1 month.
My lord. And
that is one. Just a minute. One is about chilling. Have you got that bail order copy?
That copy is not.
यहाँ नहीं कहाँ सो.
For 4 weeks. My lord.
अरे bail order copy टा कहीं?
Valid order dated 5 January 2023. That order was not with me.
Upload ही नहीं. Are you sure that your last bail application is 12822 of 2022?
Yes. Thereafter this bail application.
ए बाहर करो.
12822.
BLAPL 12822 2022. शेख सकबा अली असराय. हाँ ए पिटिशनर ठीक.
5th January.
5th January टा कौन दिखले? Scroll down. Share करो आगे. So this is for 4 weeks.
Yes, 4 weeks.
तापरा उदय.
No. More than 3 months.
You are a man from local man or outside? Udiyara.
Infocity holds or Sikharchan.
Any criminal antecedent, Mr.
My lord, he as per the rejection order, lordship, that he is associated with S.K. Phokra, who is a habitual big drug peddler of Baleshwar.
He has been granted bail. by this court. Check
You after availing that interim bail period, you surrender at
yes,
right time?
voluntarily surrender on 16th March 2023.
Heard the learned counsel for the petitioner, learned counsel for the state. Considering the submission made by the learned counsel for the petitioner that the petitioner is in judicial custody since 19/1/2020, and out of 23 charge sheet witnesses, 8 witnesses have been examined, and the petitioner was granted interim bail for a period of 4 weeks in BLAPL number 12822 12822 of 2022 as per order dated 5/1/2023, and after availing the same he surrendered at right time, and after hearing the learned counsel for the state, taking into account the delayed disposal of the trial, I am inclined to release the petitioner on interim bail for a period of 3 months. Bail application is disposed of. Will appear before the learned trial court on his date. Okay. Yes. Next.
Okay.
Item 18.
Mr. Satyabrata Das. Now the passover then.
Item 19.
Item 19 on behalf of Mr. Pradhan Madam.
Yeah.
In the meantime, trial has been commenced. May be permitted 10 days so that I will collect the deposition copy.
Deposition copy.
Yes,
Okay. Learned counsel for the petitioner 6 time to obtain the certified copy of the deposition of the witnesses examined in the trial court and to supply the same for the to the learned counsel for the state. List this matter on such and such date. Yes, next.
Okay.
Item 20.
Yes, what modification?
Yes, modification. Cash security. I'm daily wage earner.
Wait.
I have been in judicial custody.
Just a minute. आपन को जो bail दिया इतना केबे दिया इतना?
14/7/2023.
हाँ. जो
I'm prepared to.
Wait. So and so. 5 lakhs cash security and bail equal बाहर लोगों की?
नहीं. I'm recent. I am a bonded laborer because I am a daily wage earner.
नयागढ़ रहो?
Again, Fatehgarh.
अच्छा.
I have to support 6 members. I living in a 6 members dependent members.
ठीक है. अच्छा, it's a case of the year 2015.
Yes.
You are absconding for almost 8 years.
Yes.
So that is the reason why this cash security was imposed.
But on the premise of the ratio of the fund.
If you are granted bail, it's all right. We are only on the condition of waiving out the cash security amount. You are still in custody.
Yes, madam.
How much you can deposit till?
I have no property security. I have
property security
I have no property of my own. I am living in a Indira Awas house, 1-roomed house. I have to support 6 family members.
Yes, Mr. Tripathi. लोको एटिका लोको से जो फेरार रही से इतना कैश सिक्योरिटी इम्पोज कराइतला. Are the learned IA number so and so? There is an application for modification of the order dated 14/7/2023 for waiving out the cash security amount which was imposed for the condition of release on bail. Land counsel for the petitioner submitted that the petitioner's financial condition is not good and therefore he could not furnish the cash security for which, in spite of the bail order dated 14/7/2023, is still in judicial custody. after hearing the Land Council, further submit that the petitioner is ready and willing to furnish the property security of such amount, considering the submission made by the Land Council for the respective parties, and the inability of the petitioner to furnish the cash security. I modify the order dated so and so and direct that if instead of cash security of rupees 5 lakhs, if he furnishes the property security of the said amount and fulfills the other terms and conditions, the bail bond shall be accepted. Subject to so and so, the IA is disposed of. Yes.
Item 21.
Time it's coming.
Yes, yes.
Learning Council for the state seeks some time to produce the CD and CA. List this matter on such and such.
2023, my lord, arising out of same
Same,
my lord.
Same.
So if
All right.
CD is available in 23 or not?
23?
my lord.
Nine.
Yes.
Item 24.
Please, my lord. My lord, please see the last order, my lord, also passed on 5/3/2021. This is the last.
First time asked
No, not first time.
This is first time it has come.
No, it has not first time. ठीक है, दोनों सालों. The case of 2013, trial has not yet been commenced. My lord also directed to conclude the trial within 6 months in the year 2021.
ଆପଣଙ୍କୁ ସେ କଣ କହିଲେ କହିଲେ ଏଇ ଯୋଉ ମ୍ୟାଟରଟା ଏଟା ଫାର୍ଷ୍ଟ ଟାଇମ ଆସୁଛି ଆପଣ କଣ କହିଲେ ଆଗୁରୁ ଆସିଥିଲା ବୋଲି
ସାର୍
ତ ଏଇ କେସ୍ କେତେବେଳେ ଆଗୁରୁ ଆସିଥିଲା
My lord also granted it.
Another submission is that trial is not begun. Then whose deposition copy is there?
previous case ରେ
Sir,
ଆପଣ ଆସିଥିଲେ ଏଇ ମ୍ୟାଟରଟା ଏଇ ଯୋଉ ବେଲ୍ ଆପ୍ଲିକେସନଟା ଫାର୍ଷ୍ଟ ଟାଇମ ଆସିଛି ତ ସେ କେସ୍ ଡାଇରୀ ଫାଇନାନ୍ସ ସେଇଥିପାଇଁ ସେ କହୁଛନ୍ତି
my lord also granted interim bail and surrender in time.
Council for the state seeks some time to produce the case diary as well as to obtain criminal antecedent, if any, against the petitioner. Yes, next.
Item 25.
The present petitioner is inside custody since 8/11/2020.
So, the Learning Council for the state submitted on the other day that you have got 4 criminal antecedent and out of them 2 are under NDPS Act and 2 are under 307. So, time was granted to you to file a comprehensive affidavit. Have you filed? Mr. Tripathi, you have received the comprehensive affidavit?
No,
ତାଙ୍କୁ ଦେଇନାହାନ୍ତି
ଆଜି ଫାଇଲ କର
ଆଜି ତାହେଲେ ତାଙ୍କୁ ଦିଅନ୍ତୁ. If you receive it and send it to Mr.
Yes.
The Learning Council for the petitioner as per order dated 12/10/2023 files the comprehensive affidavit relating to the status of the cases instituted against the petitioner, and he also served a copy on the Learning State Council. The item number ta likhi diyantu Mr. Mishra, the jo BLAPL 7480 ବୋଲି ଲେଖା thibo. So, okay. Next. He seeks some time to go through the same, list this matter, such answer. Okay.
Item 26.
Yes, 26, Mr. Sushant Kumar Sahu. Case diary achi?
No, 302.
Okay, the none appears for the petitioner. Learning Council for the state seeks some time to produce the case diary. Also to obtain instruction about the criminal antecedent. Yes, is urgent, list this matter, Sushant. Yes, next.
Item 27.
Please, my lord. My lord, here the petitioner is languishing in jail custody since 31/12/2016. My lord, the FIR was totally unknown and also out of suspicion, he is also in custody.
Kete koile date ta kete?
Arrested 31/12/2016. 31/12/16.
And what is the stage of trial?
Trial has not yet commenced.
Status report may be called for.
The Learning Council for the petitioner submitted that the petitioner is in judicial custody since 31/12/2016 and he has got instruction that not a single witness has been examined in the trial court. Let a status report be called for from the London Session Judge Oath in ST case number 28 of 2019. Raise this matter on such and such date. Yes.
Item 28.
Sushant Kumar Lenka. Nahandi. Pass over.
CD required.
अच्छा सीडी नहीं पड़ा अच्छा ठीक है ताले এটা अर्जन कर दियंतु नॉन अपीएस कर दियंतु सीडी सीए ପାଇଁ ରଖି ଦିଅନ୍ତୁ ହେଲା
Item 29.
May I please minors? This is subsequent bail application for Lordship minor. Earlier in BL number 7567 2022, the Lordship granted 3 months interim bail.
काई से ऑर्डर काई दे
The petition in custody minor.
just ओके सेतेबेलको आपण दीटा साखी एग्जामिन हेइथिले जेतेबेले मु 3 मास बेल देली
Minor.
now the thing is that whether you surrender at right time or
Minor.
not
Surrender certificate. Sorry.
and
And
what is the present position
annexed to my lord, the page 31, the law and trial court also time of passing the order. Out of 38 charged witness, only 6 witnesses have been examined.
कोडी rejection order रे
Minor, page 31 annexed to.
page 31 automatic एसीटा बंद करनी
Page 31, minor.
out of 38 charge sheet witnesses okay that was in 4/5/2023
Minor.
so what is the position now how many further witnesses have
Mana one for my instruction yesterday, mana one witness examined in the meeting.
माने ता माने
Seven.
सातडा
Minor.
so Mr. Tripathi
Yes, my lord.
the earlier order has been complied with and he surrendered at right time
Yes, my lord.
so even half of the witnesses have also not been examined are the learned counsel for the petitioner learned counsel for the state the learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on 2/11/2020 and last time when he approached this court for bail in BLAPL number 7567 of 2022 as per order dated 27/1/2023 he was granted taking into account the delayed disposal of the trial he was granted interim bail for a period of 3 months and after availing the same he surrendered at right time learned counsel files the copy of the bail order so also the surrender certificate which are taken on record pointing out from the rejection order dated 4/5/2023 it is argued that out of 38 charge sheet witnesses she has instruction that only 7 witnesses have been examined learned counsel for the state opposed the prayer for bail considering the submission so on so for 3 months bail reason conduct of the petitioner in complying with yes disposed of
Item 28, not yes, ma'am. Item 20.
28
Madam, not yes.
BLAPL 7529 of 20 Mr. Tripathi
Yes, my lord.
there is
Yes.
no need to call for the case diary
Yes. Yes, my lord.
the learned counsel for the petitioner seeks permission to not press the application disposed of as not pressed. Yes, next.
Item 30.
May I plead the lordship, my lord? Here the petitioner custody, my lord, deposition copy, my lord.
Okay.
Yes, yes.
That
You have,
will
you have received the deposition copy?
Yes, yes, Milord. Yes,
And
yes, Milord.
that has been filed for the
filed.
court. The learned counsel for the petitioner has filed the deposition copies.
Already filed, my lord. Annex
Submitted that the deposition copies filed before this court has already been supplied to the learned counsel for the state. ତାପରେ ବାକି ତକ ଲେଖିକିନା adjourn କରିଦେବୁ. Yes, next.
Item 31.
May I please, Your Lordship?
Yes.
In this case, allegation under section 302 120B IPC.
Trace application or earlier rejected?
No, yeah, fresh application. Earlier one co-accused person released on bail.
ଆପଣ ଆସିଥିଲେ କି ଆଗରୁ?
ନାଇଁ ଆସିନି.
Case diary ଅଛି?
ଏଥିରେ deposition.
ଆଚ୍ଛା, ଟିକେ ରୁହନ୍ତୁ. Item 31 PLAPL 7946/2023. So what is the date of custody?
Custody since 31/3/2021.
Lord, this person have 7 criminal antecedents.
Okay. The learned counsel for the state submitted after verification of the case diary and instruction received that the petitioner has got 7 criminal antecedents. Let the learned counsel for the petitioner obtain instruction in respect of such antecedents and file comprehensive affidavit relating to the status of those cases, giving copy to the learned counsel for the state. Yes.
My lord, out of 31 witnesses, 18 witnesses already examined. Out of 18, 19 hostile. बाकी तक मैं दे दूची डिपोजिशन करती
हूँ। अलगा कथा सेटा परे देखाबो आगे फाइल करंतु गोटे कॉम्प्रिहेंसिव डिपोजिशन copies of the witnesses examined so far in the trial court and filed which is taken under copy देजन state counsel
देइथली 13 14 जगह आज
Yes, Milord.
Okay, deposition copy of some witnesses have been earlier supplied to the learned counsel for the state. The rest deposition copy have been supplied to the learned counsel today in court. रखंतु पठेई देबे तांपो केस नंबर लिखिन दियंतु नल कुआडे कोन मिसप्लेस हबो. Yeah.
Item 32.
Next.
Yes. Comprehensive affidavit file करंतु तां कॉपी दियंतु से 7टा केस रो कोन पोजीशन. Yes, Mr. Patnaik.
My item 32 not placed.
Mr. Patnaik, learned counsel appearing for the petitioner doesn't want to place this application. Disposed of as not placed. Yes.
Item 33.
Mr. Roy.
May I please, Your Lordship? So, case under section 20B2C of the NDPS Act, my lord. Custody since 20 March 2016.
Just a minute.
CD required, my lord. CD is not there. First time it has come.
Yes, Mr. Roy. CD not there. Learned counsel for the state seeks some time to produce the case diary as well as to obtain instruction about the criminal antecedent.
Yes, Your Lordship may call for the status report because near about 8 years in custody, my lord.
The learned counsel for the petitioner submitted that even though the petitioner has remained in judicial custody for 3 years, what is the position in the trial?
More than 8 years, my lord. Near about 8 years, my lord.
8 years. He is telling 8 years.
Since 2016 he is in custody.
Okay, 8 years is in custody and status report. Yes, next.
Item 34.
May I please, Your Lordship? I am through virtual mode, my lord.
Yes.
PD report 376.
Initially, the petitioner was released on bail by BLAPL number 2605.
Co-accused has been released on bail by lordships.
Item number. You have received the case diary, Mr.
Yes, my lord.
35 PLAPL 8235 2023. Okay, what is your custody date?
36/2023, your lordships.
30
Yes, lordships.
30/6/2023.
Yes, lordships.
Charge sheet halani.
Yes, lordships. Charge sheet has been
Under what
allowed.
offenses?
Under section 302, 120B and 34 of IPC, your lordships.
What is the name of the deceased?
Name of the deceased, your lordships, Arjun Pradhan.
Date of occurrence?
27/8/2020, your lordships. At 7:30.
27/8.
27/8/2020, your lordships.
2020.
Yes, lordships.
Okay. So eyewitnesses are there?
No eyewitness is there, but one witness, lordships, that is named Gangadhar Malla, who has seen that all the
Post occurrence witness.
post occurrence.
कौन से कहूची कौन?
That is hostile, turned hostile.
Mane start what he has been examined as PW?
This is PW, lordships. F flag mark, lordships. That is PW. PW 14, lordships.
14.
Gangadhar Malla.
Yes, lordships.
Yes.
So एपर्यंत ट्रायल रे जो विटनेस माने एग्जामिन हेलेनी आपन को विरुद्ध रे केई किछ कहि नांती?
No, lordships.
No, my lord.
Yes, Mr. Tripathi.
Yes, that is true.
Are the learned counsel for the petitioner and counsel for the state? The trial आपन कस्टडी डेट टा बोधे भूल कहउछंती 30/6/2023 केमथि हबो?
No, lordships. In view of NBW, this petition has been arrested, lordships.
Earlier you are on bail?
No, your lordships. I am not on bail.
अरे बाबू एटा सेशंस ट्रायल नंबर होची 2021
And that is also in respect of two other co-accused persons who have been released on
so
bail, lordships.
so far as you are concerned trial has not
Not
commenced.
been commenced.
The learned counsel for the so when I said that whether any of the accused persons have stated anything against you, should have told that so far as I am concerned, trial has not commenced.
Oh, lordship, sorry, your lordship, extremely sorry, lordship.
And in the deposition of the witnesses examined in respect of the co-accused person, there is nothing against you.
Yes,
that you
lordship.
should have said.
Yes, lordship.
All right. Heard the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 36/2023 and he has been charge sheeted under section 302(120)B by 34 of the Indian Penal Code. The occurrence in question took place on 27/8/2020 and there are no eyewitnesses to the occurrence relating to the commission of murder of the deceased Arjun Pradhan. So far as the co-accused persons are concerned, trial has already commenced in ST case number 26 of 2021. And even though 14 witnesses have been examined so far, in the said trial, nobody has stated anything against the petitioner and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the petitioner files the certified copy of the deposition of the witnesses which are taken on record. Learned counsel for the state, after going through the deposition copies, also fairly submits that nobody has implicated the petitioner in any manner. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, nature of evidence adduced during the trial of the co-accused persons, and period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed. Back again. Who matter? 60? Oh, that one.
Item 64.
May I please, your lordship? Lord, this is the second journey of the petitioners. The petitioners had earlier approached this honorable court in BL appeal number 63 of 2021, my lord, annexure 3. They had approached your lordship along with another accused, my lord Rohit Bispal alias Kerkeru. Later on, my lord, he has been released on bail by your lordship in BL appeal number 2551 of 2023 by order dated 28/7/2023. And another accused, Bhojaraj Bhoi alias Galu, has been released on bail by your lordship on 19/10/2023 in BL appeal number 10918 of 2023. In the earlier rejection order, my lord, the lordship had granted liberty to the petitioner to renew their prayer after examination of the charge sheeted eyewitness, my lord. The eyewitnesses have already been examined. The lordship have, my lord, already mentioned all those points in annexure 5, my lord, while granting bail to the other accused persons. Page
Rohit Biswal.
Rohit Bispal alias Kerkeru.
So and so custody and so on. So taking into account our liberty was granted to renew the prayer for after examination of eyewitnesses. As many as 12 witnesses examined, one independent witness has been examined, not supported, that the relator, like his wife and son, have stated in an omnibus manner regarding the assault of the deceased by means of swanson. So, Mr. Tripathi, this Rohit Biswal, alias Kerkeru, who is stated to have been released on bail. So, same footing.
Yes, PW 45 देखुतली.
And another accused has also been released on bail, my lord, by your lordship on 19/10, my lord. He is also on same footing that your lordship is mentioned. Bhojaraj Bhoi alias Galu.
So, what is the date of custody? Your date of custody?
My lord, 27/2020. Same date.
Same date. Are the Land Council for the petitioner, Land Council for the state? Land Council for the petitioner submitted that the petitioner is in judicial custody since 27/2020. Though his petitioners, and though their earlier bail application was rejected by this court in BLAPL number 63 of 2021, however, some of the co-accused persons similarly situated have been directed to be released on bail. In the meantime, in BLAPL number 2551 of 2023 and BLAPL number 10918 of 2023, se accused gudaकर ना लिखि देबे. सेटा होची प्रथम टा होची रोहित बिस्वाल alias केरकेरु, आ ए जो 10918 टा होची भोजराज भोई alias गालू. The Land Council submits that in view of the period of detention of the petitioner in judicial custody, the bail application may be favorably considered. Land Council for the state, after going through the evidence adduced during trial, as well as the bail orders of the co-accused persons, fairly submits that the petitioner is similarly situated like the co-accused persons who have been enlarged on bail. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced during trial, release of the co-accused persons on bail, and period of detention in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
Bless my lord. Your lordship may say petitioners, my lord. Two petitioners.
Petitioners, for the petitioners.
Grateful, my lord.
Yes.
Lord, in IA 297,
Lordship has passed order, my lord, that is 22/9/2023, my lord. In IA 297, my lord, Lordship has passed order, my lord, that is order dated 22/9/2023, my lord. Praying for peruse that, my lord.
Learned counsel for the petitioner submitted, or even though the petition was directed to be released on bail, grants of fund for cash security. Acha. Petitioner is unable to furnish the same. Okay. Waived and okay. Local surety upon Kwaitla name, address, and documents daba pai.
My lord.
And have you given it to
Yes,
them? And what instruction you have received?
I am given.
Yadi on the con instruction asla.
Then
Is a local man or outsider?
Outsider.
You are directed to be released on bail on 21/12/2020.
Yes, yes,
Still then you are not.
yes, report also called for, my lord. Report also tagged.
No,
with
that's
lordship.
all right. But why you sought modification at such an inordinate delay? Jadi माने 2020 ରୁ आपन बेल दिया हला जदी असुविधा थिला आपन 2023 पर्यंत चुपचाप काई बसी गले कोन आसिला रिपोर्ट कोन जेन्युइन पर्सन हां
and two statement also recorded.
All right. So what are the names of soda indicate करिया पड़ियो से दी जण ना कोन
दी जण ना हला first na hला Kamal
Lochon Christian. Acha.
And the second one is
Ananta Turuk. Lekhon, the Learned Counsel for the petitioner, IA number 297 of 2023. This is an application for modification of order dated 21/12/2020. तापरे जो 22/9/2023 रो फर्स्ट सने थर्ड सप्ताह रे जा अछि पूराटा टिपी देबे है ना as per order dated 22/9/2023 the Learned Counsel for the petitioner supplied the names, address, and documents of two local sureties who were interested to take the petitioner on bail. The Learned Counsel for the state for verification stopped. Today, the Learned Counsel for the state has obtained instruction from IIC Semligura Police Station, Koraput, to the effect that the two local sureties, namely Kamal Lochon Christian and Anant Turuk, are genuine persons and their address is correct, and they have also given written consent to stand surety for the petitioner, and that they have got no criminal antecedents. Considering the submission made by the Learned Counsel for the respective parties, since in spite of the bail order dated 21/12/2020, the petitioner couldn't able to furnish the cash security, the said order is modified and is directed to be released on bail by furnishing bail bond of ₹2 lakh with two local sureties, and those two local sureties are Kamal Lochon Christian and Anant Turuk. And the terms and conditions except the cash security amount shall stand confirmed. With the aforesaid observation, the IA stands disposed of. Cash security amount is waived. Cash security amount is waived, and these two local securities shall furnish the ये, है ना?
May dealership Miller, here custody 24 to 2000.
Yes, yes.
Status report.
221. Yes.
Custody 24/2/2020 Miller.
এটা ରଖନ୍ତୁ। हाँ, କଣ ହେଲା custody?
24 to 2020. And last occasion, my lord call for the status report.
Status report ଆସିଲା କି?
ଆସିଛି।
Flag M. Okay. I am to submit that one so accused persons were forwarded 21/6 so okay. Charge of this case was framed on 15/11/22. One witness has been examined. Total witness कितने?
Total witness 22 Miller. 22
ଗୋଟିଏ ସାକ୍ଷୀ ଜମା ହେଇଛି। ଲୋକ କୋଉଠିକାର?
ବାଲେଶ୍ୱର ରହିଲିନି Miller।
ଆଗରୁ ଯାଇନଥିଲେ?
ନା ମୋଟେ ଯାଇନି, କେବଳ 21 ମସିହାରେ ମତେ ଟ୍ରାଏଲ ଏକ୍ସପିଡିଏନ୍ସ ହେଇଥିଲା। BLAPL 3726 of 2000.
Right. Heard the learned counsel for the petitioner and counsel for the state. Considering the submission made by the learned counsel for the petitioner that the petitioner is in judicial custody since 24/2/2020 and he has been charge sheeted under section 21C and 29 of the NDPS Act. And in the trial court, out of kete witness kale?
22 Miller.
Out of 22 charge sheet witness, only one witness has been examined, which also appears from the status report furnished by the learning trial court. And further submission of the learned counsel that the petitioner is a local man. I'm inclined to release the petitioner on interim bail for a period of 3 months. He shall appear before the learning trial court on each date when the case would be posted for obliged. Disposed of here. Rest of the matter no prove nahi ase.
Item 168, my lord, which is lordship, I have intimated the vigilance
next week.